Series of constitution. Now I am talking about fundamental rights and fundamental duties. The Constitution of England is unwritten, hence there is in England no code of fundamental rights as exists in the Constitution of the United States or in other written constitution of the world. This does not mean, however, that in England there is no recognition of the fundamental of the individual without which democracy becomes this does not mean, however, that in England there is no recognition of those basic rights of the individual without which democracy becomes meaningless. The object, in fact, is secured here in a different way. The foundation of the individual rights in England may be said to be negative in the sense that an individual has the right and freedom to take whatever action he likes so long as he does not violate any rule of the ordinary law of the land. Individual liberty is secured by judicial decisions determining the rights of individuals in particular cases brought before the courts. The judiciary is the guardian of individual rights in England as elsewhere, but there is a fundamental difference. While in England the courts have the fullest power to protect the individual against executive tyranny, the courts are powerless as against legislative aggression upon individual rights. In short, there is no fundamental rights binding upon the legislature in England. The English Parliament being theoretically omnipotent, there is no law which it cannot change. As has been already said, the individuals has rights, but they are found on the ordinary law of the land, which can be changed by parliament like other laws. So there is no right which may be said to be fundamental in the strict sense of the term. Another vital consequence of the supremacy of parliament is that the English court has no power of judicial review over legislation at all. It cannot declare any law as unconstitutional on the ground of contravention of any supposed fundamental or natural rights. The fundamental difference in approach to the question of individual rights between England and the United States is that while the English were anxious to protect individual rights from the abuses of executive power, the framers of the American Constitution were apprehensive of tyranny not only from the executive but also from the legislature. That is a body of men who for the time being form the majority in the legislature. So the American Bill of Rights contained in the first 10 amendments of the Constitution of the USA is equally binding upon the legislature as upon the executive. The result has been the establishment in the United States of the judicial supremacy as opposed to the parliamentary supremacy in England. The courts in the United States are competent to declare an act of Congress as unconstitutional on the ground of contravention of any provision of the Bill of Rights. Further, it is beyond the competence of the legislature to modify or adjust any of the fundamental rights in view of any emergency or danger to the state. That power has been assumed by the judiciary in the United States. In India, the Simon Commission and the Joint Parliamentary Committee, which were responsible for the Government of India Act 1935, had rejected the idea of enacting declarations of fundamental rights on the ground that abstract declarations are useless unless there exists the will and the means to make them effective. But nationalist opinion since the time of the Nehru Report was definitely in favor of the Bill of Rights, because the experience gathered from the British regime was that a subservient legislature might serve as a handmaid to the executive in committing inroads upon individual liberty, regardless of the British opinion. Therefore, the makers of our Constitution adopted fundamental rights to safeguard individual liberty and also for ensuring, together with the directive principles, social, economic, and political justice for every member of the community, that they have succeeded in this venture in the testimony of an ardent observer of the Indian Constitution. In India, it appears that fundamental rights have both created a new equality and have helped to preserve individual liberty. The number of the rights cases brought before high courts and the Supreme Court attest to the value of the rights, and the frequent use of prerogative writs testifies to their popular acceptance as well. The classic arguments against the inclusion of written rights in a constitution have not been borne out in India. In fact, the reverse may have been the case. So the Constitution of India has embodied a number of fundamental rights in Part 3 of the Constitution, which are subject to the exceptions to be mentioned thereafter, to act as limitations not only upon the powers of the executive but also upon the powers of legislature. Though the model has been taken from the Constitution of the United States, the Indian Constitution does not go so far. The rather affects the compromise between the doctrines of parliamentary sovereignty and judicial supremacy. On the other hand, the Parliament of India cannot be said to be sovereign in the English sense of legal omnipotence, for the very fact that the Parliament is created and limited by the written Constitution enables our Parliament to legislate only subject to the limitations and prohibitions imposed by the Constitution, such as the fundamental rights, the distribution of legislative powers, etc. In case any of these limitations are transgressed, the Supreme Court and the High Courts are competent to declare a law as unconstitutional and void. So far as the contravention of fundamental rights is concerned, this duty is specially enjoined upon the courts by the Constitution. Article 13, by way of abundant caution, Clause 2 of Article 13 says, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made the contravention of this clause shall, to the extent of the contravention, be void. To this extent, our Constitution follows the American model rather than English. The powers of the judiciary vis-a-vis the legislature are weaker in India than in the United States in two respects. Firstly, fundamental rights under Indian Constitution distinguished from American Bill of Rights. Firstly, while the declaration of the American Bill of Rights are absolute and the power of the state to impose restrictions upon the fundamental rights of the individual in the collective interests had to be evolved by the judiciary. In India, this power has been expressly conferred upon the legislatures by the Constitution itself in the case of the major fundamental rights, of course, leaving a power of judicial review in the hands of the judiciary to determine the reasonableness of the restrictions imposed by the legislature. 44th Amendment 1978, the right to property. Secondly, by somewhat hasty step, the Janata government headed by Morarji Desai had taken out an important fundamental right, namely the right of property, by omitting Article 19(1)(f) and 31 by the 44th Amendment Act 1978. Of course, the provision in the same amendment being transposed to a new been transposed to a new article 300A, which is outside part 3 of the constitution and has been labeled as chapter 4 of part 12, which deals with finance, property, contracts and suits. But this is not a fundamental right. While under the Congress rule for 30 years, the ambit of fundamental rights embodied in part 3 of the original constitution had been circumscribed by multiple amendments. Bit by bit, the death blow to one of the fundamental rights came from the Janata government. The net result of the foregoing amendments inflicted upon the right to property are the right not to be deprived of one's property save by authority of law is no longer a fundamental right. Hence, if anybody's property is taken away by exhaustive fiat without the authority of law or in contravention of a law, the aggrieved individual shall have no right to move the Supreme Court under Article 32. If a legislature makes a law depriving a person of his property, he cannot challenge the reasonableness of the restriction imposed by such law, invoking Article 19(1)(f), because that provision has ceased to exist. Since Clause 2 of Article 31 has vanished, the individual's right to property is no longer a guarantee against the legislature in respect of any compensation for loss of such property. Article 31(2) in the original constitution embodied the principle that if the state makes a compulsory acquisition or requisitioning of private property, it must make a law. B, such law must be for the public purpose, and C, some compensation must be paid to the expropriated owner. Of course, by the 25th Amendment of 1971, during the regime of Mrs. Gandhi, the requirement of compensation was replaced by an amount, the adequacy of which could no longer be challenged before the courts. Nevertheless, the Supreme Court held the aggrieved individual might complain if the amount so offered was illusory or amounted to confiscation, but even such an innocuous possibility has been foreclosed by the 44th Amendment. The short argument advanced in the statements of objects and reasons of the 45th Amendment for deleting the fundamental right to property is that it was only being converted into a legal right. What is meant is that while Article 19(1)(f) and 31(2) of the original Constitution operated as limitations on the legislature itself, the 45th Amendment will installs the legislature as a guardian of the individual's right to property without any fetter on its goodwill and wisdom. But if the legislature could be presumed to be infallible and innocent, this would be a good argument for omitting all the fundamental rights from Part 3. As it has been pointed out earlier, the very justification of putting limitations on the legislature by adopting a guarantee of fundamental rights is that history has proved that the group of human beings constituting for the time being the majority in a legislative body are not always infallible, and that is why the constitutional safeguards are necessary to permanently protect the individual from legislative tyranny. Thirdly, by subsequent amendments, the arena of fundamental rights has been narrowed down by introducing certain exceptions to the operation of fundamental rights, namely Article 31A, 31B, 31C, and 31D. Of these articles, 31A, 31C are exceptions to the fundamental rights enumerated in Article 14 and 19. This means that any law falling under the ambit of Article 31A, as for example, a law for agrarian reform, or Article 31C, a law for the implementation of any of the directive principles contained in Part 4 of the Constitution, cannot be invalidated by any court on the ground that it contravenes any of the fundamental rights guaranteed by Article 14, equality before law, Article 19, freedom of expression, assembly, etc. Article 31B, however, offers almost complete exception to all the fundamental rights enumerated in Part 3 if any enactment is included in 9th schedule, which is to be read along with Article 31B, then such enactments shall be immune from constitutional invalidity on the ground of contravention of any of the fundamental rights, but shall be open to challenge on the ground of damage to the basic structure of the Constitution subsequent to 24/4/1973, that is the date of decision of Keshavanand's case. Fourthly, by the 42nd Amendment Act 1976, a contravening factor has been introduced, namely the fundamental duties mentioned in Article 51A, though these duties are not themselves enforceable in the courts, nor their violation as such punishable. Nevertheless, if a court before which a fundamental right is sought to be enforced has to read all parts of the Constitution, it may refuse to enforce a fundamental right at the instance of an individual who has patently violated any of the duties specified in Article 51A. If so, the emphasis of the original Constitution on fundamental rights has been minimized. Fifthly, the correct category of the fundamental rights under our Constitution is exhaustively enumerated in Part 3 of the Constitution, and American Constitution 9th Amendment expressly says that the enumeration of certain rights in the Bill of Rights shall not be construed to deny or disparage other retained by the people. This rests on the theory of inalienable natural rights, which can by no means be lost to the individual in a free society. The guarantee of some of them in the written Constitution cannot therefore render obsolete any right which inhered in the individual even before the Constitution, as for example the right to engage in political activity, but there is no such unenumerated right under our Constitution. As was observed in the early case of Gopalan versus state of Maharashtra, the legislatures under our Constitution being sovereign except in so far as their sovereignty has been limited by the Constitution, either expressly or by necessary implication, the courts cannot impose any limitation upon the sovereignty either on the theory of the spirit of Constitution or of that of natural rights, that is, rights other than those which are enumerated in Part 3 of the Constitution. Any expansion of the fundamental rights under the Indian Constitution must therefore rest on judicial interpretation, and the Supreme Court has gone ahead in this direction by enlarging the scope of Article 21. It should not be supposed, however, that there is no other justiciable right provided by our Constitution outside Part 3. Limitations upon the state are imposed by other provisions of the Constitution, and these limitations give rise to corresponding rights to the individual to enforce them in a court of law if the executive or the legislature violates any of them. Thus, Article 265 says that no tax shall be levied on collected except by the authority of law. This provision confers a right upon an individual not to be subjected to arbitrary taxation by the executive, and if the executive seeks to levy a tax without legislative sanction, the aggrieved individual may have his remedy from the courts. The new provision in Article 300A belongs to this category. Similarly, Article 301 says that subject to the provisions of this part, trade, commerce and intercourse throughout the territory of India shall be free. If the legislature or the executive imposes any restriction upon the freedom of trade or intercourse which is not justified by the other provisions of Part 13 of the Constitution, the individual who is affected by such restriction may challenge the action by appropriate legal proceeding. When then is the distinction between the fundamental rights included in Part 3 of the Constitution and those rights arising out of the limitations contained in the other parts which are equally justiciable? Though the rights of both these classes are equally justiciable, the constitutional remedy by the way of an application direct to the Supreme Court under the Article 32, which is itself included in Part 3 as a fundamental right, is available only in the case of fundamental rights. If the right follows from some other provisions of the Constitution, say Article 265 or Article 301, the aggrieved person may have his relief by an ordinary suit or by an application under Article 226 to the High Court. But an application under Article 32 shall not lie unless the invasion of the non-fundamental right invokes the violation of some fundamental rights as well. As the word fundamental suggests, under some constitution, fundamental rights are immune from constitutional amendments. In other words, they are conferred a special sanctity as compared with other provisions of the Constitution. But this principle has been rejected by the Indian Constitution as it stands interpreted by amendments of the Constitution themselves and judicial decisions. Of course, no part of the Constitution of India can be changed by ordinary legislation unless so authorized by the Constitution itself, as for example Article 4. But all parts of the Constitution except the basic feature can be amended by the Amendment Act passed under Article 368, including the fundamental rights. This proposition has been established after a history of its own. Until the case of Golaknath, the Supreme Court has been holding that no part of our Constitution was unamendable and that Parliament might, by passing a Constitution Amendment Act in accordance with the requirements of Article 368, amend any provision of the Constitution, including the fundamental rights and Article 368 itself. According to this earlier view, thus the court could act as a guardian of the fundamental rights only so long as they were not amended by the Parliament of India by the required majority of the votes. In fact, some of the amendments of the Constitution so far made were effected with a view to suppress superseding judicial pronouncements which had invalidated social or economic legislation on the ground of contravention of fundamental rights. Thus, the narrow interpretation of Clause 2 of Article 19 by the Supreme Court in the cases of Ramesh Thapar versus State of Madras and Brijbhushan versus State of Delhi was superseded by the Constitution First Amendment Act 1951, while the interpretation given to Article 31 in the cases of State of West Bengal versus Gopal, Dwarika Das versus Solapur Spinning Company and State of West Bengal versus Bela Banerjee was superseded by the Constitution Fourth Amendment Act 1955. But the Supreme Court cried halt to the process of amending the fundamental rights through the amending procedure laid down in Article 368 of the Constitution by its much debated decision in Golaknath versus State of Punjab. In this case, overruling its two earlier decisions, the Supreme Court held the fundamental rights embodied in Part 3 has been given a transcendental position by the Constitution, so that no authority functioning under the Constitution, including Parliament Parliament exercising the amending power under Article 368 was competent to amend the fundamental rights. C. But by the 24th Amendment Act 1971, Article 13 and Article 68 were amended to make it clear that fundamental rights were amendable under the procedure laid down in Article 368, thus overriding the majority decision of the Supreme Court in Golaknath versus State of Punjab. The majority decision in Keshavanand Bharati case upheld the validity of these amendments and also overruled Golaknath's case, holding that it is competent for Parliament to amend fundamental rights under Article 368, which does not make any exception in favor of the fundamental rights, nor does 13 comprehend acts amending the Constitution itself. At the same time, Keshavananda's case also laid down that there were implied limitations on the power to amend, and that power cannot be used to alter the basic feature of the Constitution. A big limitation that stands in the way of Parliament acting by a special majority to introduce drastic changes in the Constitution is the judicially innovated doctrine of basic features, which can be eliminated only if a bench larger than the 13-judge bench of in Keshavanand's case be prepared to overturn the decision in that case. In the meantime, applying Keshavananda's, the majority of the Constitution bench has invalidated clause 4 and 5 of Article 368 as violative of the basic features of the Constitution. Minervaville versus Union of India, 1980 Supreme Court 1789, para 21 and 28. The provisions of Part 3 of our Constitution, which enumerate the fundamental rights, are more elaborate than those of any other existing written constitution relating to fundamental rights and cover a wide range of topics. The Constitution itself classifies the fundamental rights under 7 groups as follows: right to equality, right to particular freedoms, right against exploitation, right to freedom of relation, cultural and educational rights, right to property, right to constitutional remedies. Of these, the right to property has been eliminated by 44th Amendment Act, so that only 6 freedoms now remain in Article 19(1). The rights falling under each of the 6 categories are shown in the Table 5. Another classification which is obvious is from the point of view of persons to whom they are available. Thus, some of the fundamental rights are granted only to citizens. First, protection from discrimination on ground only of religion, race, caste, sex, or place of birth. Article 15. Equality of opportunity in matters of public employment. Article 16. Freedoms of speech, assembly, association, movement, residence, and profession. Article 19. Cultural and educational rights of minorities. Article 30. Some of the fundamental rights, on the other hand, are available to any person on the soil of India, citizen or foreigner. Equality before the law and equal protection of the law. Article 14. Protection in respect of conviction against ex post facto laws, double punishment and self-incrimination. Article 20. Protection of life and personal liberty against action without authority of law. Article 21. Right against exploitation. Article 23. Freedom of relation. Article 25. Freedom as to payment of taxes for the promotion of any particular religion. Article 27. Freedom as taxes for the freedom as to attendance at religious instruction or worship in state educational institution. Article 28. Some of the fundamental rights are negatively worded as as prohibition to the state. As for example, Article 14 says, the state shall not deny to any person equality before the law. Similar are the provisions of Article 15(1), 16(2), 18(1), 20, 22(1), 28(1). There are others which positively confer some benefits upon the individual, as for example the right to religious freedom under Article 25 and the cultural and educational rights under Article 29(1)(31). Still another classification may be made from the standpoint of the extent of limitation imposed by the different fundamental rights upon legislative power. On the one hand, we have some fundamental rights such as under Article 21 which are addressed against the executive but impose no limitation upon the legislature at all. Thus Article 21 simply says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. It was early held by our Supreme Court that a competent legislature is entitled to lay down any procedure for the deprivation of personal liberty, and that the courts cannot interfere with such law on the ground that it is unjust, unfair, and unreasonable. In this view, the object of Article 21 is not to impose any limitation upon the legislative power, but only to ensure that the executive does not take away a man's liberty except under the authority of a valid law, and in strict conformity with the procedure laid down by such law. In later case, however, the Supreme Court has found it difficult to immunize laws made under Article 21 from the attack on the ground of unreasonableness under the relevant clauses of Article 19(1) or Article 14, and recent Supreme Court decisions show an increasing inclination in that direction. To the other extreme are fundamental rights which are intended as absolute limitations upon the legislative power, so that it is not open to the legislature to regulate the exercise of such rights, as for example the rights guaranteed by Article 15, 17, 18, 20, 24. In between the two classes stand the rights guaranteed by Article 19, which itself empowers the legislature to impose reasonable restrictions upon the exercise of these rights in the public interest. Though the individual rights guaranteed by Article 19 are in general binding upon both the executive and the legislature, these authorities are permitted by the Constitution to make valid exceptions to the rights within limits imposed by the Constitution. Such grounds in brief are security of the state, public order, public morality, and the like. All the above rights are available against the state. It is now settled that the rights which are guaranteed by Article 19 and 21 are guaranteed against state action, as distinguished from violation of such rights by private individuals. In the case of violation of such rights by individuals, the ordinary legal remedies may be available, but not the constitutional remedies. State action in this context must, however, be understood in a wider sense, for interpreting the word state wherever it occurs in the part on fundamental rights. A definition has been given in Article 12, which says that unless the context otherwise requires, the state will include not only the executive and legislative organs of the union and state, but also local bodies such as municipal authorities as well as other authorities. This latter expression refers to any authority or body of persons exercising the power to issue orders, rules, bylaws, or regulation having the force of law. As for example, a board having the power to issue statutory rules for exercising governmental powers, even the fact of a private individual may become an act of the state of it is enforced or added by any of the authorities just referred to. It should be noted, however, that there are certain rights included in Part 3 which are available not only against the state but also against private individuals. For example, Article 51, Clause 2, equality in regard to access to and use of places of public resort. Article 17, prohibition of untouchability. Article 18, 3 to 4, prohibition of acceptance of foreign title. Article 23, prohibition of traffic in human beings. Article 24, prohibition of employment of children in hazardous employment. But these provisions in Part 3 are not self-executory. That is to say, these articles are not directly enforceable. They would be indirectly enforceable. Only if some law is made to give effect to them and such law is violated, it follows that classification of fundamental rights, not executory and self-executory, is another possible mode of classification. We may now proceed to a survey of the various fundamental rights. In particular, Article 14 of the Constitution provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. We must know about the Article 14 of our Constitution, which provides the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. This is very important. Prima facie, the expression equality before the law and equal protection of the laws may seem to be identical, but in fact they mean different things. While equality before the law is a somewhat negative concept, implying the absence of any special privilege by reason of birth, creed, or the like in favor of any individual, and the equal subjection of all classes to the ordinary law. Equal protection of law is more positive concept, implying the right to equality of treatment in equal circumstances. The concept of equality and equal protection of laws in its proper spectrum encompasses social and economic justice in a political democracy. Equality before law, as a student of English constitutional law knows, it is the second corollary from Dicey's concept of the rule of law. Equality before law is correlative to the concept of rule of law for all-round evaluation of healthy social order. It means that no man is above the law of the land and that every person, whatever be his rank or status, is subject to the ordinary law and amenable to the jurisdiction of any ordinary tribunal. Against every citizen, from the Prime Minister down the humblest peasant, is under the same responsibility for every act done by him without lawful justification, and in this respect there is no distinction between officials and private citizens. It follows that the position will be the same in India. But even in England, certain exceptions are recognized to the above rule of equality in the public interest. The exceptions allowed by the Indian Constitution are: the President or the Governor of the state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. No criminal proceeding whatsoever shall be instituted or continued against the President president or a governor in any court during his term of office. No civil proceeding in which relief is claimed against the president or the governor of the state shall be instituted during his term of office in any court in respect of any act done or purporting to be done by him in his personal capacity, whether before or after he entered upon his office as president or governor of such state, until the expiration of 2 months next after notice in writing has been delivered to the president or the governor, as the case may be, or left at his office, stating the nature of proceedings, the cause of action, therefore, the name, description, any place of residence of the party by whom such proceedings are to be instituted, and the relief which he claims. Article 361. The above immunities, however, shall not bar the impeachment proceeding against the president, suits or other appropriate proceedings against the governor of India or the governor of a state. Besides the above constitutional exceptions, there will of course remain the exceptions acknowledged by the Committee of Nations in every civilized country, as for example, in favor of foreign sovereigns and ambassadors. Equal protection of laws. Equal protection of laws, on the other hand, would mean that among equals the law should be equal and equally administered, that like should be treated like. Equal protection requires affirmative action by the state towards unequals by providing facilities and opportunities. In other words, it means that right to equal treatment in similar circumstances, both in the privileges conferred and in liabilities imposed by the law. None should be favored and none should be placed under any disadvantage in circumstances that do not admit of any reasonable justification for a different treatment. Thus, it does not mean that every person shall be taxed equally, but the persons under the same character should be taxed by the same standard. But if there is any reasonable basis for classification, the legislature would be entitled to make a different treatment. The legislature is competent to exercise its discretion and make classification. It is for the legislature to identify the class of the people to be given protection and on what basis such protection was to be given. The court cannot interfere. A state has wide discretion in respect of the classification of objects, persons and things for the purposes of taxation. The legislature can devise classes for the purpose of taxing or not taxing, exempting or not exempting, granting incentives and prescribing rate of tax, benefits and concessions. Thus, it may first exempt certain classes of property from taxation at all, such as charities, libraries, and like. Impose different specific taxes upon different trades and professions, tax real and personal property in different manner, and so on. The guarantee of equal protection thus is a guarantee of equal treatment of persons in equal circumstances, permitting differentiation in different circumstances. In other words, the principle of equality does not mean that every law must have universal application for all persons who are not by nature, attainment or circumstance in the same position, as the varying needs of different classes of persons often require separate treatment. The principle does not take away from the state the power of classifying persons for legitimate purposes. A legislature which has to deal with diverse problems arising out of an infinite variety of human relations must of necessity have the power of making special laws to attain particular objects, and for that purpose it must have large powers of selection or classification of persons and things upon which such law are to operate. In order to be reasonable, a classification must not be arbitrary but must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in odd others who are left out, but those qualities or characteristics must have a reasonable relation to the object of legislation. The reasonableness of a provision depends upon the circumstances obtaining a particular time and the urgency of the evil sought to be controlled. The possibility of the power being abused is no ground for declaring a provision violative of Article 14. In order to pass the test, two conditions must be fulfilled, namely that first, classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and second, that differentia must have a rational relation to the object sought to be achieved by the act. It is not possible to exhaust the circumstances or criteria which may accord a reasonable basis for classification in all cases. It depends on the sub-object of the legislation in view, and whatever has a reasonable relation to the object or purpose of the legislation is a reasonable basis for classification of the persons or things coming under the purview of the enactment. Thus, the basis of classification may be geographical. The classification may be according to difference in time. The classification may be based on the difference in the matter of the trade, calling, or occupation which is sought to be regulated by the legislation. Similarly, higher educational qualification is a permissible basis of classification for promotion, as it has nexus with higher efficiency on the promotional post. Thus, it has been held that in offences relating to women, adultery, women in India may be placed in a more favorable position having regard to their social status and need for protection. In the law of prohibition, it would not be unconstitutional to differentiate between civil and military personnel or between foreign visitors and Indian citizens, for they are not similarly circumstanced from the standpoint of need for prohibition of consumption of liquor. Exemption to the candidate who stood first in the Forest Rangers College from selection as assistant conservator by the Public Service Commission, it being based on reasonable qualification, it not ultra vires Article 14. The guarantee of equal protection applies against substantive as well as procedural laws. The decision-making process should be transparent, fair, and open. The procedure for distribution of state largesses must be transparent, just, fair, and non-arbitrary. Non-transparency promotes nepotism and arbitrariness. Hence, the discretion vested by the statute is to be exercised fairly and judicially and not arbitrarily, but subject to the requirements of law. In the absence of rules, the action of government is required to be fair and reasonable. From the standpoint of the latter, it means that all litigants who are similarly situated are able to avail themselves of the same procedural rights for relief and for defense without discrimination discrimination. Of course, if the differences are of a minor or of unsubstantial character which have not prejudiced the interest of the person or persons affected, there would not be a denial of equal protection. Again, a procedure different from that laid down by the ordinary law can be prescribed for the particular class of persons if the discrimination is based upon the reasonable classification having regard to the object which the legislation has in view and the policy underlying it. Thus, in a law which provides for the externment of undesirable persons who are likely to jeopardize the peace of the locality, it is not an unreasonable discrimination to provide that a suspected person shall have no right to cross-examine the witness who depose against her, for the very object of the legislation, which is an extraordinary one, would be defeated if such a right were given to the suspected person. In the reference on the Special Courts Bill 1978, the Supreme Court has held that the setting up of a special court for the expeditious trial of offences committed during the emergency period from 25/6/1975 to 27/3/1977 by high public officials in view of the congestion of work in the ordinary criminal courts and in view of the need for a speedy termination of such prosecutions in the interest of the functioning of democracy under the Constitution of India as a reasonable classification. But to include in bill any offence committed during any period prior to the proclamation of emergency in June 1975 was unconstitutional inasmuch as such classification has no reasonable nexus with the object of the bill. The guarantee of the equal protection includes absence of any arbitrary discrimination by the laws themselves or in the matter of their administration. Thus, even where a statute itself is not discriminatory, but the public official entrusted with the duty of carrying it into operation applies to against an individual not for the purpose of the act but intentionally for the purpose of injuring him. The latter may have an executive act annulled by the court on the ground of contravention of the guarantee of equal protection. Of course, it is for the aggrieved individual to establish beyond doubt that the law was applied against him by the public authority with an evil eyes and an unequal hand. In short, Article 14 hits arbitrariness of state action in any form. An act which is discriminatory is liable to be labeled as arbitrary. The court will not interfere in the policy decisions of the government unless the government action is arbitrary or indivisible discriminatory. The government policy is not subject to judicial review unless it is demonstrably arbitrary, capricious, irrational, discriminatory, or violative of constitutional or statutory provisions. In the duty of a state to allay fears of citizens regarding discrimination and arbitrariness, however, protective discrimination in favor of Supreme Courts and in favor of scheduled castes and scheduled tribes is a part of constitutional scheme of social and economic justice to integrate them into the national mainstream so as to establish an integrated social order with equal dignity of persons. Relation between Article 14 to 16, as the Supreme Court has observed, Articles 14 to 16 taken together enshrine the principle of equality and absence of discrimination. While the principle is generally stated in Article 14, which extends to all persons, citizens or aliens, since Article 15 and 16 deal with particular aspect of that equality. Thus, Article 15 is available to citizens only, and it prohibits discrimination against any citizen in any matter at the disposal of the state or any of the specified grounds, namely religion, race, caste, sex, or place of birth. Article 16 is not confined to citizens, but it is restricted to one aspect of public discrimination, namely employment under the state. In matters not coming under Article 15 and 16, if there is any discrimination or validity of that can be challenged under the general provision in Article 14. As just stated, a particular aspect of the equality guaranteed by Article 14 is the prohibition against discrimination contained in Article 15 of the Constitution, which runs thus. The state shall not discriminate against any citizen on ground only of religion, race, caste, sex, place of birth, or any of them. No citizen shall on ground only of religion, race, caste, sex, place of birth of any of them, subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. Nothing in this article shall prevent the state from making any special provision for women and children. Nothing in this article in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. It will be seen that the scope of this article is very wide. While the prohibition in clause 1 is labeled against state action, the prohibition in clause 2 is labeled against individuals as well. Clause 1 says that any act of state, whether political, civil, or otherwise, shall not discriminate as between citizens on grounds only of religion, race, caste, sex, place of birth, or any of them. The plain meaning of this prohibition is that no person of a particular religion, caste, etc. shall be treated unfavorably by the state when compared with persons of any other religion or caste merely on the ground that he belongs to the particular religion or caste, etc. The significance of the word only is that if there is any other ground or consideration for the differential treatment besides those prohibited by this article, the discrimination will not be unconstitutional. Thus, discrimination in favor of a particular sex will be permissible if the classification is the result of other consideration besides the fact that the persons belong to that sex, as for example physical or intellectual fitness for some work. For instance, women may be considered to be better fitted for the jobs of a nurse, while they may not be considered eligible for employment in heavy industries like steel factory. Such discrimination being based on a ground other than sex would not be considered to be unconstitutional. But if a person is sought to be discriminated against simply because he belongs to a particular community, race, or sex, he can get the state action annulled through a court. While racial discrimination still persists as a malignant growth upon Western society, it speaks volumes of Indian achievement achievement that a possible victim of racial discrimination in India can obtain relief direct from the highest court of the land by means of a petition for an appropriate rate, and yet no such complaint has so far come before the courts. As already stated, in regard to the public places specified in clause 2, the protection is available even against discriminatory act by private individuals. Clause 2 provides that so far as places of public entertainments are concerned, no person shall be subjected to discrimination on the grounds only of religion, race, caste, sex, place of birth, or any of them. Whether such discrimination is the result of an act of the state or of any other individual, even wells, tanks, bathing ghats, roads and places of public resort which are owned by private individual are subject to this prohibition, provided they are maintained wholly or partly out of the state funds, or they have been dedicated to the use of general public. The above prohibition against discrimination, however, would not preclude the state from making special provisions for women and children, making special provision for the advancement of any socially and educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. These exceptional classes of people require special protection, and hence any legislation which is necessary for the making of special provisions for persons of these classes would not be held to be unconstitutional. Thus, it has been held that a section 497 of Indian Penal Code, which lays that in an offence of adultery, though the man is punishable for adultery, the woman is not punishable as an abettor, is not unconstitutional, because such immunity is necessary for the protection of women in view of their existing position in Indian society. Similarly, though discrimination on the ground of caste only is prohibited by clause 1 of the article, it would be permissible under clause 4 for the state to reserve seats for the members of the backward classes or of the scheduled caste or tribes, or to grant them fee concessions. In public educational institutions, Article 15(4) envisages the policy of compensatory or protective discrimination, but it should be reasonable and consistent with the ultimate public interest, that is national interest and the interest of community or society as a whole. But the provision cannot be justifiably invoked in a granting remission to the convicted persons belonging to the scheduled caste and scheduled tribes, as it would not be a measure to their advancement. However, the benefit obtained was permitted to be retained. It was held that an SC/ST candidate selected for admission to a course on the basis of merit as a general candidate should not be treated as a reserved candidate, and the reservation for admission to the specialties, super specialties in postgraduate and doctoral course in medicine is permissible. As a corollary from the general assurance of absence of discrimination by the state on grounds only of religion, race, caste, sex, or place of birth, Article 15, the Constitution guarantees equality of opportunity in matters of public employment. Article 16 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any of office under the state. No citizen shall on ground only of religion, race, caste, sex, descent, place of birth, or any of them be ineligible for any office under the state. The true import of equality of opportunity is not simply a matter of legal equality. Its existence depends not merely on the absence of disabilities, but on the presence of abilities and opportunity of excellence in each cadre grade. And equality of opportunity means equality as between the members of the state class of employees and not between that of a separate independent classes. A person cannot be excluded from a state service merely because he is a Brahmin, even though this result is reached by reason of a distribution of posts amongst communities according to a ratio or quota. Government jobs or service cannot be denied to the person suffering from AIDS. This equally is to be observed by the state not only in the matter of appointments to the public services but also in the matter of any other public employment where the relationship of master and servant exists between the state and the employees. It bars discrimination not only in the matter of initial appointment but also of promotion and termination of the service itself. And employment includes promotion. This right is a safeguard not only against communal discrimination but also against local discrimination or even against discrimination against the weaker sex. The only exception to the above rule of equality are residents within the state may be laid down by Parliament as a condition for particular classes of employment of appointment under any state or other local authority. Article 16(3). By virtue of this power, Parliament enacted the Public Employment Requirement as to Residence Act 1957, empowering the Government of India to prescribe residence as condition for employment in certain posts and services in the state of Andhra Pradesh and in the Union Territories of Himachal Pradesh, Manipur and Tripura. This act having expired in 1974, there is no provision to prescribe residence as a condition for public employment, except that for Andhra Pradesh special provisions have been made by inserting a new Article 371D in the Constitution itself. The state may reserve any post or appointment in favor of any backward class of citizens who, in the opinion of state, are not adequately represented in the services under the state. Article 16(4). This is to provide socio-economic equality to the disadvantaged. Offices connected with a religious or denominated institution may be reserved for members professing the particular religion or belonging to the particular denomination to which the institution relates. Article 16(5). The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration in the matter of appointment to services and posts under the Union and the states, so far as may be consistent with the maintenance of efficiency of the administration. Article 335. But the proviso to the Article 335 providing for giving relaxation in qualifying marks in any examination or lowering the standard of evaluation in favor of the members of the SC/ST hits the consideration of maintenance of efficiency in administration and has done away with the emphasis on it laid down the apex court in some cases. The Supreme Court has held that while Article 16(4) is apparently without any limitation upon the power of the reservation conferred by it, it has to be read together with Article 335, which enjoins that in taking into consideration the claims of the member of the scheduled caste and scheduled tribes in the making of appointments in connection with the affairs of the Union or a state, the policy of the state should be consistent with the maintenance of efficiency of administration. The result is that there can be no doubt that the constitution makers assumed that while making adequate reservation under Article 16(4), care would be taken not to provide for unreasonable, excessive or extravagant reservation. Therefore, like the special provision improperly made under Article 15(4), reservation made under Article 16(4) beyond the permission and legitimate limits would be liable to be challenged challenged as a fraud on the Constitution. It is to be noted carefully that the prohibition against discrimination in the matter of public employment is attracted where the discrimination is based only on any of the grounds enumerated, namely religion, race, caste, sex, descent, place of birth or residence. It does not prevent the state, like other employers, to pick and choose from a number of candidates either for appointment or for promotion on grounds of efficiency, discipline, and the like. It is also to be noted that though reservation in favor of backward classes is permissible under clause 4 of Article 16, no such reservation is possible in favor of women, nor in any other discrimination in favor of women possible, as for example relaxation of rules of recruitment or standard of qualification or the like. For the furtherance of social equality, the Constitution provides for the abolition of the evil of untouchability, Article 17, and the prohibition of conferring titles by the state. A 9-judge bench of the Supreme Court has, in Indra Sahni's case, popularly known as the Mandal Commission case, laid down the following important points which summarize the law on the issue of reservations in government employment. For further discussion, authors shorter the Constitution 13th edition under Article 16.4. Article 16.4 is exhaustive of the provisions that can be made in favor of the backward classes in the matter of employment. Backward classes of citizens is not defined in the Constitution. There is an integral connection between caste, occupation, poverty, and social backwardness. In the Indian context, lower castes are treated as backwards. A caste may be itself constitute a class. The backward classes can be identified in Hindu society with reference to castes along with other criteria such as traditional occupation, poverty, place of residence, lack of education, etc. And in communities where caste is not recognized, the rest of the criteria would apply. The backwardness contemplated by Article 16.4 is mainly social. It need not to be both social and educational. Men's test signifies imposition of an income limit for the purpose of excluding persons from backward classes. Those whose income is above that limit are referred to as creamy layer income, or the extent of property can be taken as a measure of social advancement, and on that basis the creamy layer of a given caste can be excluded. For getting reservations, a class must be backward and should not be adequately represented in the services under the state. The reservations contemplated in Article 16.4 should not exceed 50%. The rule of 50% should be applied to each year. It cannot be related to the total strength of class, service, or cadre, etc. Reservation of posts under Article 16.4 is confined to initial appointment only and cannot extend to providing reservation in the matter of promotion. If the reservation in promotion exists, it shall continue for 5 years. 16th November 1997 by the Constitution 77th Amendment Act 1995. This limitation of time has been removed by inserting clause 4A to enable it to continue reservation in promotion for the scheduled caste and scheduled tribes. Identification of backward classes is subject to judicial review. It is to be noted that many states are attempting to surpass the 50% limit. All those cases are under the consideration of the Supreme Court. The vacancies reserved could be carried forward for a maximum period of 3 years if candidates from backward classes are not available, after which they were to lapse. By inserting clause 4B in Article 16 by the Constitution 81st Amendment Act 2000, the state has been empowered to consider such unfilled vacancies as a separate class to be filled up in any succeeding years or years. Article 17 of the Constitution says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Parliament is authorized to make a law prescribing the punishment for this offence under Article 35, and in exercise of this power, Parliament has enacted the Untouchability Offences Act 1955, which has been amended and renamed in 1976 as the Protection of Civil Rights Act 1955. The word untouchability has not, however, been defined either in the Constitution or in the above Act. It has been assumed that the word has a well-known connotation, primarily referring to any social practice which looks down upon certain depressed classes solely on account of their birth and disables them from having any kind of intercourse with people belonging to the so-called higher classes or castes. This act declares certain acts as offences when done on the ground of untouchability and prescribes the punishments therefore, as for example, refusing admission to any person to public institutions such as hospital, dispensary, educational institution, preventing any person from worshipping or offering prayers in any place of public worship, subjecting any person to any disability with regard to access to any shop, public restaurants, hotel, public entertainments, or with regard to the use of any reservoir, tap, or other source of water, road, cremation ground, or any other place where service are rendered to the public. The sweep of the Act has been enlarged in 1976 by including within the offence of practicing untouchability the following: insulting a member of scheduled caste on the ground of untouchability, preaching untouchability directly or indirectly, justifying untouchability on historical, philosophical, or religious grounds, or on the ground of tradition of the caste system. The penal section has been enhanced by providing that in the case of subsequent convictions, the punishment may range from 1 to 2 years imprisonment. A person convicted of the offence of untouchability shall be disqualified for election to the union or the state legislature. If member of the scheduled caste is subjected to any such disability or discrimination, the court shall presume, unless the contrary is proved, that such act was committed on the ground of untouchability. In other words, in such cases there will be a statutory presumption of an offence having been committed under this act. The prohibition of untouchability in the Constitution has thus been given a realistic and effective shape by this act. Abolition of titles. Article 18. Title is something that hangs to one's name as an appendage. During the British rule, there was a complaint from the nationalists that the power to confer titles was being abused by the government for imperialistic purposes and for corrupting public life. The Constitution seeks to prevent such abuse by prohibiting the state from conferring any title at all. It is to be noted that the ban operates only against the state. It does not prevent other public institutions such as universities to confer titles or honors by way of honoring their leaders for men of merit. The state is not debarred from awarding military or academic distinctions, even though they may be used as titles. The state is not prevented from conferring any distinction or award, say for social service, which cannot be used as a title, that is, as an appendage to one's name. Thus, the award of Bharat Ratna or Padma Vibhushan cannot be used by the recipient as a title and does not accordingly come within the constitutional provision. In 1954, Government of India introduced decorations in the form of medals for 4 categories, namely Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. While the Bharat Ratna was to be awarded for exceptional services towards the advancement of art, literature, and science and in recognition of public service of the higher order. The others would be awarded for distinguished public service in any field, including service rendered by government servants in order of the degree of the merit of their service. Though the foregoing awards were made decorations and not intended to be used as appendages to the names of the person to whom they are awarded, there was a vehement criticism from some quarters that the introduction of these awards violated Article 18. The critics pointed out that even though they may not be used as titles, the decorations tend to make distinctions according to rank, contrary to the preamble, which promises equality of status. The critics gained strength on this point from the fact that the decorations are divided into several classes, superior and inferior, and that holders of the Bharat Ratna have been assigned a place in the warrant of procedure, ninth place, that is just below the cabinet ministers of the Union, which is usually meant for indicating the rank of the different dignitaries and high officials of the state. In the interest of discipline in the administration, the result was the creation of a rank of persons on the basis of government recognition in the same way as the conferment of nobility would have done. Another criticism which seems to be legitimate is that there is no sanction either in the Constitution or in any existing law against a recipient of any such decoration appending it to his name and thus using it as a title. Any such use is obviously inconsistent with the prohibition contained in Article 18(1), but it is not made an offense either by the Constitution or by any law. The apprehensions of the critics on this point were unfortunately justified by the fact that in describing the author on the title of an issue of the Hamelin lectures, the decoration Padma Vibhushan was in fact appended as a title. The protest raised by Acharya Kripalani against the award of such decorations, which went unheeded earlier, was honored by the Janta regime 1977 by putting a stop to the practice of awarding Bharat Ratna etc. by the government. But it was restored by Mrs. Gandhi after her comeback. In this context, it is to be noted that Article 18(1) itself makes an exception in favor of granting by the state of any military or academic distinction. The matter was taken to court, and the Supreme Court has now held that non-military awards by way of recognition of merit of extraordinary work, as for example the Padma Awards, are not titles of nobility and hence do not violate Article 14 or 18, provided they are not used as titles or prefixes or suffixes to the names of the awardee. Apart from the rights flowing from the above prohibition, certain positive rights are conferred by the Constitution in order to promote the ideal of liberty held out by the preamble. The foremost amongst these are the 6 fundamental rights in the nature of freedom, which are guaranteed to the citizens by the Constitution of India, Article 19. These were popularly known as the 7 freedoms. Under our Constitution, it has already been pointed out that in the original Constitution there were 7 freedoms in Article 19(1), but that one of them, namely the right to acquire, hold or dispose of properties, has been omitted by the Constitution 44th Amendment Act 1978, leaving only 6 freedoms in this article. They are freedom of speech and expression, freedom of assembly, freedom of association, freedom of movement, freedom of residence and settlement, freedom of profession, occupation, trade and business. Article 19 forms the core of our chapter on fundamental rights. It is essential for the readers to be familiar with the text of this article as it stands amended. All citizens have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions, to move freely throughout the territory of India, to reside and settle in any part of India, and to practice any profession or to carry on any occupation, trade or business. Nothing in subclause A of clause 1 affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of right conferred by the said subclause in the interests of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, poor order, public order, decency or morality, or in relation contempt of court, defamation or incitement to an offense. Nothing in subclause B of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interests of the sovereignty and integrity of India or public order reasonable restrictions on the exercise of the right conferred by the said subclause. Nothing in the subclause C of the said clause shall affect the operation of any existing law in so far as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of India or public order or morality reasonable restrictions on the exercise of the right conferred by by the said subclause. Nothing in the subclause D, E of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any of the rights conferred by the said subclause either in the interest of the general public or for the protection of the interest of any scheduled tribes. Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to the professional and technical qualification necessary for practicing any profession or carrying on any occupation, trade or business, or the carrying on by the state or by the corporation owned or controlled by the state of any trade, business, industry or service, whether to the exclusion complete or partial of citizen or otherwise any modern state. The guarantee of each of the above rights is therefore limited by our Constitution itself by conferring upon the state a power to impose by its laws reasonable restrictions as may be necessary in the larger interests of the community. This is what is meant by saying that the Indian Constitution attempts to strike a balance between individual liberty and social control. Since the goal of our constitutional system is to establish a welfare state, the makers of the Constitution did not rest with the enumeration of uncontrolled individual rights in accordance with the philosophy of laissez-faire, but sought to ensure that where collective interests were concerned, individual liberty must yield to the common goods, but instead of leaving it to the courts to determine the grounds and exempt of permissible state regulation of individual rights as the American Constitution does, the makers of our Constitution specified the preamble limitations in clause 2 to 6 of article 19 itself. The state in this context includes not only the legislative authorities of the union and the states but also other local or statutory authorities, as for example municipalities, local boards, etc., within the territory of India or under the control of the government of India. So all of these authorities may impose restrictions upon the above freedoms, provided such restrictions are reasonable and are relatable to any of the goods of public interest as specified in clause 2 to 6 of article 19. Thus the Constitution guarantees freedom of speech and expression, but this freedom is subject to reasonable restrictions imposed by the state relating to defamation, contempt of court, decency or morality, security of the state, friendly relations with foreign state, incitement to an offense, public order, maintenance of sovereignty and integrity of India. Decency or morality is not confined to sexual morality alone. It indicates that the action must be in conformity with the current standards of behavior or propriety. Hence, seeking votes at an election on the ground of the candidate's religion in a secular state is against the norms of decency and propriety of the society. It is evident that the freedom of speech and expression cannot confer upon an individual a license to commit illegal or immoral acts or to incite others to overthrow the established government by force or unlawful means. No one can exercise his rights of speech in such a manner as to violate another man's such right. Similarly, the freedom of assembly is subject to disqualification that the assembly must be peaceable and without arms and subject to such reasonable restrictions as may be imposed by the state in the interests of the public order. In other words, the right of meeting or assembly shall not be liable to be abused so as to create public disorder or a breach of the peace or to prejudice and sovereignty or integrity of India. Again, all citizens have the right to form associations or unions, but subject to reasonable restrictions imposed by the state in the interests of public order or morality or the sovereignty or integrity of India. Thus, this freedom will not entitle any group of individuals to enter into a criminal conspiracy or to form any association dangerous to the public peace or to make illegal strikes or to commit a public disorder or to undermine the sovereignty or integrity of India. Similarly, though every citizen shall have the right to move freely throughout the territory of India or to reside and settle in any part of the country, this right shall be subject to restrictions imposed by the state in the interests of the general public or for the protection of any scheduled tribes. Again, every citizen has the right to practice any profession or to carry on any occupation, trade or business, but subject to reasonable restrictions imposed by the state in the interests of the general public and subject to any law laying down qualifications for carrying on any profession or technical occupation or enabling the state itself to carry on any trade or business to the exclusion of the citizens. Scope for judicial review. As pointed out earlier, one of the striking features of the provisions relating to fundamental rights in our Constitution is that the very declaration of the major fundamental rights is attended with certain limitations specified by the Constitution itself. In the United States, the Bill of Rights itself does not contain any such limitation to the rights of the individual guaranteed thereby, but in the enforcement of those rights, the court had to invent doctrines like like that of police power of the state to impose limitations on the rights of the individual in the interests of the community at large. But as explained above in Article 19 of our Constitution, there is distinct clause attached to each of the rights declared containing the limitations or restrictions which may be imposed by the state or the exercise of each of the rights so guaranteed. For example, while the freedom of speech and expression is guaranteed, an individual cannot use this freedom to defame another, which constitutes an offense under the law. A law which may be made by the state under any of the specified grounds, such as public order, defamation, contempt of court, cannot be challenged as unconstitutional or inconsistent with the guarantee of freedom of expression, except where the restrictions imposed by the law can be held to be unreasonable by a court of law. That is how the competing interests of individual liberty and of public welfare have been sought to be reconciled by the framers of our Constitution, as Justice Mukherjee explained in the leading case of Gopalan versus State of Madras. There cannot be any such thing as absolute or uncontrolled liberty wholly freed from restraint, for that would lead to anarchy and disorder. The possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed to be to the governing authority of the country to be essential to the safety, health, peace, general order and morals of community. The question therefore arises in each case of adjusting the conflicting interests of the individual and of the society. Ordinarily, every man has the liberty to order his life as he pleases, to say what he will, to go where he will, to follow any trade, occupation or calling at his pleasure, and to do any other thing which he can lawfully do without let or hindrance by any other person. On the other hand, for every protection of these liberties, the society must arm itself with certain powers. What the Constitution therefore attempts to do in dealing the rights of the people is to strike a balance between individual liberty and social security. Article 19 of the Constitution gives the list of individual liberties and prescribes in the various clauses the restraints that may be placed upon them by law, so that they may not conflict with public welfare or general morality. It is by way of interpretation of word reasonable that the court comes into the field, and in each case when an individual complains to the court that his fundamental rights has been infringed by the operation of a law or an executive order issued under a law, the court has get to determine whether the restriction imposed by the law is reasonable, and if it is held to be unreasonable in the opinion of the court, the court will declare the law and the order, if any, to be unconstitutional and void. Tests of reasonableness of a restriction. The expression reasonable restriction seeks to strike a balance between the freedom guaranteed by any of the sub-clauses of Article 19(1) and the social control permitted by any of the exceptions in Clause 2 to 6. It is to be seen, therefore, what criteria or tests has been laid down by the Supreme Court for determining whether the restriction is reasonable or not. The Supreme Court has said that a restriction is reasonable only when there is a proper balance between the rights of the individual and those of the society. The test of reasonableness should therefore be applied to each individual statute impugned, and not abstract or general pattern of reasonableness can be laid down as applicable to all cases. The nature of the right alleged to have been infringed, the underlying purpose of the restriction imposed, the extent and urgency of evil sought to be remedied thereby, the disproportion of the imposition, the prevailing conditions at the time should all enter into the judicial verdict. Thus, the formula of subjective satisfaction of the government and its officers with an advisory board to review the materials on which the government seeks to override a basic freedom guaranteed to the citizen may be viewed as reasonable only in very exceptional circumstances, as for example in providing internment or externment for the security of the state and within the narrowest limits, and not to curtail rights such as the freedom of association in the absence of any emergent or extraordinary circumstances. All the attendant circumstances must be taken into consideration, and one cannot dissociate the actual contents of the restrictions from the manner of their imposition or the mode of putting them into practice. The Supreme Court has held that in examining the reasonableness of a statutory provision, whether it is violated the fundamental rights guaranteed under Article 19, one has to keep in mind the directive principles of the state policy. The restrictions must not be arbitrary or an excessive nature, going beyond the requirements of the interest of general public. No abstract or general pattern or a mixed principle to judge the reasonableness of the restrictions can be laid down so as to be of universal application, and the same will vary from case to case, as also with regard to the changing conditions, values of human life, social philosophy of the Constitution, prevailing conditions, and surrounding circumstances. A just balance has to be struck between the restrictions imposed and social control envisaged by Article 19(6). Prevailing social values as also social needs which are intended to be satisfied by the restrictions, there must be a direct and proximate nexus or reasonable connection between the restrictions imposed and the object sought to be achieved by the act. That being so, a strong presumption in favor of the constitutionality of the act will naturally arise. It follows, therefore, that the question of reasonableness should be determined from both the substantive and procedural standpoints. Hence, in order to reasonable, the restriction imposed must have a reasonable relation to the collective object which the legislation seeks to achieve, and must not go in excess of that object. Or, in other words, the restriction must not be greater than the mischief to be prevented. Legislation which arbitrarily or excessively invades the right cannot be said to contain the quality of reasonableness. Thus, the object of an act was to provide measure for the supply of adequate labor for agriculture process in beedi manufacturing areas, but the order of the Deputy Commissioner made thereunder forbade all persons residing in certain villages from engaging in the manufacture of beedis during the agricultural season. The Supreme Court invalidated the order on the ground that it imposed an unreasonable restriction upon the freedom of business, Article 19(1)(g) of those engaged in the manufacture of beedis, because the object of the act could be achieved by legislation restraining the employment of agricultural labor in the manufacture of beedis during the agricultural season, or by regulating hours of work on the business of making beedis. A total prohibition of the manufacture imposes an unreasonable and excessive restriction on the lawful occupation of the manufacturing beedis. While the foregoing aspect may be said to be the substantive aspect of reasonableness. There is another aspect, which the procedural aspect relating to the manner in which the restrictions have been imposed. That is to say, in order to be reasonable, not only the restriction must not be excessive, the procedure or manner of imposition of the restriction must also be fair and just. In order to determine whether the restrictions imposed by law are procedurally reasonable, the court must take into consideration all the attendant circumstances, such as the manner of its imposition, the mode of putting it into practice. Broadly speaking, a restriction is unreasonable if it is imposed in a manner which violates the principle of natural justice. For example, if it seeks to curtail the right of association or the freedom of business of a citizen without giving him an opportunity to be heard, it has also been laid down that in the absence of extraordinary circumstances, it would be unreasonable to make the exercise of a fundamental right depend upon the subjective satisfaction of the executive. There is no specific provision in our Constitution guaranteeing the freedom of the press, because freedom of the press is included in the wider freedom of expression, which is guaranteed by Article 19(1)(a). Freedom of expression means the freedom to express not only one's own views but also the views of others, and by any means, including printing. But since the freedom of expression is not an absolute freedom and is subject to the limitations contained in Clause 2 of Article 19, laws may be passed by the state imposing reasonable restrictions on the freedom of the press in the interests of the security of the state, the sovereignty and integrity of India, friendly relations with foreign states, public order, decency or morality, or for the prevention of contempt of court, defamation or incitement to an offense. Absolute, unlimited and unfettered freedom of press at all times and in all the circumstances would lead to disorder and anarchy. The press as such has no special privileges in India from the fact that the measure of freedom of the press is the same as that of an ordinary citizen. Under Article 19(1)(a), several propositions emerge. The press is not immune from the ordinary forms of taxation, the application of the general laws relating to industrial relations, the regulation of the condition of service of the employees. But in view of the guarantee of freedom of expression, it would not be legitimate for the state to subject the press to laws which take away or abridge the freedom of expression or which would curtail circulation and thereby narrow the scope of dissemination of information or fetter its freedom to choose its means of exercising the right, or would undermine its independence by driving it to seek government aid. To single out the press for laying upon it excessive and prohibitive burdens which would restrict the circulation, impose or penalty on its right to choose the instruments for its exercise, or to seek an alternative media. To impose a specific tax upon the press deliberately calculated to limit the circulation of information when the constitutionality of an enactment especially directed against the press is challenged, the court has to test it by the standard of substantive and procedural reasonableness. As explained earlier, an enactment of this nature, the Punjab Special Powers Press Act 1956 came up before the Supreme Court in Virendra versus State of Punjab, and the court annulled one of its provisions while upholding another on the following grounds: a law which empowers the government to prohibit for any temporary period the entry of literature of a published specified class likely to cause communal disharmony would not be held to be reasonable if it complies with the procedural requirements of natural justice, but it would be unreasonable if it empowered the state government to prohibit the bringing into the state of any newspaper on its being satisfied that such action was necessary for the maintenance of communal harmony or public order, inasmuch as it placed the whole matter at the subjective satisfaction of the state government without even providing for the right of representation to the party affected. Since the expiry of the Press Objectionable Matter Act 1951 in 1956, there was no All India Act for the control of the press in India, but in 1976 Parliament enacted the Prevention of Publication and Objectionable Matter Act 1976 with more rigorous provisions and in a permanent form. In April 1977, the Janata government repealed this act. Subsequently, however, this position was further buttressed by inserting a new article in the Constitution itself, Article 361A by the Constitution 44th Amendment Act 1978. Censorship of the press again is not especially prohibited by any provision of the Constitution like other restrictions. Therefore, its constitutionality has to be judged by the test of reasonableness within the meaning of Clause 2. Soon after the commencement of the Constitution and prior to the insertion of the word reasonable in Clause 2, the question of validity of censorship came up before our Supreme Court in the case of Brij Bhushan versus State of Delhi. The fact of this case were as follows: Section 7(1)(c) of the East Punjab Safety Act 1949 provided that the provincial government, if satisfied that such action is necessary for preventing or combating any activity prejudicial to the public safety or the maintenance of public order, may, by order in writing, addressed to a printer, publisher, editor, require that any matter relating to a particular subject or class is subject shall before publication be submitted for scrutiny. Similar provisions of the Madras Maintenance of Public Order Act 1949 were challenged in the allied case of Ramesh Thapar versus State of Madras. The majority of the Supreme Court had no difficulty in holding that the imposition of pre-censorship on a journal was an obvious restriction upon the freedom of speech and expression guaranteed by Clause 1A of the Article 19, that public safety or public order was not covered by the expression security of the state, and impugned law was not therefore saved by Clause 2 as it then stood. After these decisions, Clause 2 was amended by the Constitution First Amendment Act 1951, inserting public order in Clause 2. Hence, the ground relied upon by the majority in the cases of Ramesh Thapar and Brij Bhushan is no longer available. The word reasonable was also inserted in Clause 2 by the same amendment. The result of this twofold amendment is that if censorship is imposed in the interests of public order, it cannot at once be held to be unconstitutional as fetter upon the freedom of circulation, but its reasonableness has to be determined with reference to the circumstances of its imposition. In this sense, the introduction of the word reasonable has not been an unmixed blessing, for censorship of the press in times of peace is something unimaginable either in England or in the United States in modern times. But under our constitution, as the Supreme Court decision in Birendra versus State of Punjab suggests, even at the time of peace, censorship may be valid if it is subjected to reasonable safeguards, both from the substantive and procedural standpoints, but not otherwise. The provisions before the court were sections 2 and 3 of the Punjab Special Powers Press Act 1956, which were similar to that in Section 71C of the East Punjab Public Safety Act 1949, which had been impugned in Brij Bhushan's case, except that in the Act of the 1956, what was authorized was even more drastic than pre-censorship, with a total prohibition. The court held that Section 2, which provided for a right of representation against the order of the authority and limited the power to a specific period and as to publications of a specified class, was valid. But Section 3, which had no such safeguards, constituted an unreasonable restriction. It would therefore follow that a provision for pre-censorship for a limited period in emergent circumstances and subject to procedural safeguards, as for example, as in Section 144 of Criminal Procedure Code, is valid. If, however, it is left to the absolute discretion of the executive authority, it must be held to be unreasonable. The Supreme Court has similarly upheld the validity of law sanctioning pre-censorship of motion pictures to protect the interests safeguarded by Article 19(2), as for example, public order and morality. It should be noted that when a proclamation of emergency is made under Article 352, Article 19 itself remains suspended, Article 358, so that pre-censorship may be imposed without any restraint. Thus, immediately after the proclamation of emergency on the ground of internal disturbance in June 1975, a censorship order was issued June 26, 1975 under Rule 48(1) of the Rules made under the Defence and Internal Security of India Act 1971. It should be noted that on the defeat of Mrs. Gandhi at the election of 1977, the proclamation of internal emergency was revoked on 21st and the press censorship order was revoked on the 22nd of March 1977. Article 9 would also be applicable in cases where Article 31A to 31C are attracted. These exceptions to fundamental rights, which have been introduced by subsequent amendments, will be discussed at the end of this chapter. Article 20 guarantees protection in certain respects against conviction for offences by prohibiting retrospective criminal legislation, commonly known as ex post facto legislation. Double jeopardy or punishment for the same offence more than once, compulsion to give self-incriminating evidence. A provision against ex post facto legislation is contained in Clause 1 of Article 20 of our Constitution, which runs as follows. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. This is a limitation upon the law-making power of the legislatures in India. A law is said to be prospective when it affects acts done or omission made under the law comes into effect. The majority of law are prospective in their operation, but sometimes the legislature may give retrospective effect to a law. That is to say, to bring within the operation of the law not only future acts and omissions, but also acts or omissions committed even prior to the enactment of the law in question. Though ordinarily a legislature can enact prospective as well as retrospective laws, according to the present clause, a legislature shall not be competent to make a criminal law retrospective so as to provide that a person may be convicted for an act which was not an offense under the law in force at the time of commission of that act, or to subject an accused to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offense. In other words, when the legislature declares an act to be an offense or provides a penalty for an offense, it cannot make the law retrospective so as to prejudicially affect the person who have committed such acts prior to the enactment of that law. The prohibition against double jeopardy is contained in clause 2 of Article 20, which runs thus: no person shall be prosecuted and punished for the same offense more than once. The expression double jeopardy is used in the American law but not in our Constitution. Nevertheless, Clause 2 of Article 20 in effect lays down a similar principle as has been laid down by the Supreme Court in Venkataramanan versus Union of India. Article 22 refers to the judicial punishment and gives immunity to a person from being prosecuted and punished for the same offense more than once. In other words, if a person has been prosecuted and punished in a previous proceeding of an offense, he cannot be prosecuted and punished for the same offense again in a subsequent proceeding. If any law provides for such double punishment, such law would be void. The article, however, does not give immunity from proceedings other than proceedings before a court of law or a judicial tribunal. Hence, a government servant who has been punished for an offense in a court of law may yet be subjected to departmental proceedings for the same offense, or conversely, the immunity from self-incrimination is conferred by Clause 3 of Article 20, which says no person accused of any offense shall be compelled to be a witness against himself. The scope of this immunity has prima facie been widened by our Supreme Court by interpreting the word witness to comprise both oral and documentary evidence, so that no person can be compelled to furnish any kind of evidence which is reasonably likely to support a prosecution against him. Such evidence must, however, be in the nature of a communication. The prohibition of is not attracted where any object or document is searched and seized from the possession of the accused. For the same reason, the clause does not bar the medical examination of the accused or the obtaining of thumb impression or specimen signature from him. Secondly, the immunity does not extend to civil proceedings or other than criminal proceeding. It has also been explained by the Supreme Court that in order to claim the immunity from being compelled to make a self-incriminating statement, it must appear that a formal accusation has been made against the person at the time when he is asked to make the incriminating statement. He cannot claim the immunity at the same general inquiry or investigation on the ground that his statement may at some later stage lead to an accusation. Freedom of person or personal liberty is sought to be ensured by our Constitution by means of twofold guarantee, namely by providing that no person can be deprived of his liberty except according to law, Article 21. by laying down certain specific safeguards against arbitrary arrest or detention. Article 22, Article 21 of our Constitution provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This article reminds us of one of the famous clauses of the Magna Carta: no man shall be given or imprisoned, deceased, or outlawed, or exiled, or in any way destroyed, save by the law of the land. It means that no member of the executive shall be entitled to interfere with the liberty of a citizen unless he can support his action by some provision of law. In short, no man can be subjected to any physical coercion that does not admit of legal justification. When therefore the state or any of its agents deprives an individual of his personal liberty, such action can be justified only if there is law to support such action and the procedures prescribed by such law have been strictly and scrupulously observed. Again, as under the English Constitution, personal freedom is secured by the Indian Constitution by the judicial writ of habeas corpus. See under habeas corpus Article 32 and 226, by means of which an arrested person may have himself brought before the court and have the ground of his imprisonment examined. And again, his freedom, if the court finds that there is no legal justification for his imprisonment, the court will also set the prisoner free where there is a law authorizing the deprivation of liberty of a person. But there has been no strict compliance with the conditions imposed by the law. The Supreme Court has more than once observed that those who feel called upon to deprive other persons of their personal liberty in the discharge of what they conceive to be their duty must strictly and scrupulously observe the forms and rules of the law. But in no country can there be any absolute freedom of the individual. The principle underlying the English Constitution is that it is the people's representatives assembled in Parliament which shall determine how far the rights of the individual should go and how far they should be curtailed in the collective interests or for the security of the state itself according to exigencies of the time. This was the theory adopted by the Constitution of India in saying that life and personal liberty are subject to the procedure established by law. The Supreme Court has, however, infused judicial review by holding that procedure inherently meant a fair procedure, so that Article 21 has been turned into a safeguard against arbitrary legislation. The history of this change in view is as follows. Until the 1978 decision in Menka's case, the view which prevailed in our Supreme Court was that there was no guarantee in our Constitution against arbitrary legislation encroaching upon personal liberty. Hence, if a competent legislature makes a law providing that a person may be deprived of his liberty in certain circumstances and in a certain manner, the validity of law could not be challenged in the court of law on the ground that law is unreasonable, unfair, or unjust. Under the Due Process Clause of the American Constitution, 15th and 14th Amendment, the court has assumed the power of declaring unconstitutional any law which deprives a person of his liberty otherwise than in accordance with the court's notion of due process, in accordance with the court's notion of due process, that is reasonable and fairness. In England, this is not possible inasmuch as courts have no power to invalidate a law made by Parliament. In the result, personal liberty is in England a liberty confined and controlled by law. It exists only so far as it is not taken away or limited by laws made by the representatives of the people. In Gopalan versus State of Madras, The majority of our Supreme Court propounded the view that by adopting the expression procedure established by law, Article 21 of our Constitution had embodied in English concept of personal liberty in preference to that of American due process, even though according to the minority, the result of such interpretation was to throw the most important fundamental right to life and personal liberty at the mercy of legislative majorities. The result, according to the majority, is due to the difference in the basic approach, namely that although our Constitution has imposed some limitations on the legislative authorities, yet subject to and outside such limitation, our Constitution has left our Parliament and the state legislatures supreme in their respective fields. In the main, our Constitution has preferred the supremacy of the legislature to that of the judiciary. It was also held that there is no safeguard for personal liberty under our Constitution besides Article 21, such as natural law or common law. In the result, when personal liberty is taken away by a competent legislation, the person affected can have no remedy. It is a striking feature of the development of constitutional law of India that after a long struggle, which may be said to have started tangibly since 1971, the minority view in Gopalan's case has come to triumph in seven-judge decision in Menka's case, which we have already noted. This case has categorically laid down the following propositions, overturning the majority in Gopalan. Article 19 and 21 are not watertight compartment. On the other hand, the expression of personal liberty in Article 21 is of the widest amplitude, covering a variety of rights in which some have been included in Article 19 and given additional protection. Hence, there may be some overlapping between Article 19 and 21. In the result, a law coming under Article 21 must also satisfy the requirements of Article 19. In other words, a law made by the state which seeks to deprive a person of his personal liberty must prescribe a procedure for such deprivation which must not be arbitrary, unfair, and unreasonable. Once the test of reasonableness is imported to determine the validity of law depriving a person of his liberty, it follows that such law shall be invalid if it violates the principle of natural justice. As for example, if it provides for the impounding of a passport without giving a person affected an opportunity to be heard or to make a representation against the order proposed. From Gopalan to Menika, thus the judicial exploration has completed its trek from the north to south pole. The decision in Menka's case is being followed by the Supreme Court in subsequent cases. Apart from the foregoing judicial salvage, let us now advert to the safeguards which the Constitution itself has provided in Article 22 against arbitrary arrest and detention. Hence, in a case coming under Article 22, the requirements of both Article 21 and 22 must be complied with. The procedural safeguards against arbitrary arrest and detention provided for in Clause 1 and 2 of Article 22 are: no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. No such person shall be denied the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of arrest, excluding the time necessary for the journey from the place of the arrest to the court of the magistrate, and no such person shall be detained in custody beyond beyond the said period without the authority of a magistrate. The above safeguards are not, however, available to an enemy alien, a person arrested or detained under the law providing for preventive detention. The Constitution itself authorizes legislature to make law providing for preventive detention for reasons connected with the security of a state, the maintenance of public order, or the maintenance of supplies and services essential to the community, or for reasons connected with defense, foreign affairs, or the security of India. So it would be competent to the legislature to enact that a person should be detained or imprisoned without trial for any of the above reason, and against such laws the individual shall have no right of personal liberty. The Constitution, however, imposes certain safeguards against abuse of the above power. Article 22, Clause 4 to 7. It is these safeguards which constitute fundamental rights against arbitrary detention, and it is because of these safeguards that preventive detention has found a place in the Part 2 of Fundamental Rights in our Constitution. The relevant provisions of Article 22 read as follows. When a person has been arrested under the law of preventive detention, the government is entitled to detain such person in custody only for 3 months. If it seeks to detain the arrested person for more than 3 months, it must obtain a report from an advisory board who will examine the papers submitted by the government and by the accused as to whether the detention is justified. The person so detained shall, as soon as may be informed of the ground of his detention, accepting facts which the detaining authority considers to be against the public interest to disclose. The person detained must have the earliest opportunity of making a representation against the order of detention. A law which violates any of the conditions imposed by Article 22, as stated above, is liable to be declared invalid, and an order of detention which violates any of these conditions will similarly be invalidated by the court, and the detainee shall forthwith be set free. Parliament has the power to prescribe by law the maximum period for which a person may be detained under the law of preventive detention. Preventive detention means detention of a person without trial. It is so called in order to distinguish it from punitive detention. The object of punitive detention is to punish a person for what he has done, and after he is tried in the courts for the illegal act committed by him. The object of preventive detention, on the other hand, is to prevent him from doing something, and the detention in this case takes place on the apprehension that he is going to do something wrong which comes within any of the grounds specified by the Constitution. This acts prejudicial to the security of the state, public order, maintenance of supplies and services essential to the community, defense, foreign affairs, or security of India. In fact, preventive detention is resorted to in such circumstances that the evidence in possession of the authority is not sufficient to make a charge or to secure the conviction of the detainee by legal proof, but many still be sufficient to justify his detention on the suspicion that he would commit a wrongful act unless he is detained. Preventive detention is something unknown in the United States of America or the United Kingdom in times of peace. The adoption in India on a permanent footing of the power of the executive to arrest persons on suspicion, which is tolerated in other countries only in emergencies, cannot on principle be justified by any lover of liberty, but no proper assessment of this provision of our Constitution is possible without taking note of the following circumstances. Firstly, detention without trial was not a new idea introduced by the makers of our constitution for the first time. It was in existence since the early days of British India. Under the notorious Bengal Regulation, 3rd of 1818, the Bengal State Prisoners Regulation, and similar enactments in Madras and Bombay, which laid no fetters upon the powers of the government to detain a person on suspicion. Then came Rule 26 of the rules framed under the Defence of India Act 1939, which authorized the government to detain a person whenever it was satisfied with respect to that particular person that such detention was necessary to prevent him from acting in any manner prejudicial to the defense and safety of the country and the like. This was, of course, a wartime measure modeled on similar legislation in England during World War II, the validity of which had been upheld by the House of Lords. But even after the cessation of the war, preventive detention was continued in India as an instrument to suppress apprehended breach of public order, public safety, and the like by the Provincial Maintenance of Public Order Acts, under which there was a spate of litigation. The framers of our constitution simply made it possible for such legislation to be continued under the constitution, subject to certain safeguards laid down therein, because they painfully visualized that the circumstances which had necessitated such abnormal legislation in the past had not disappeared at the birth of India's independence. It is common knowledge that the Republic had its birth amidst anti-social and subversive forces and the ravages of communal madness involving colossal loss of lives and property. In order to save the infant republic from the inroads of any such subversive elements, therefore this power had to be conferred upon the state. But the framers of the constitution improved upon the existing law by subjecting the power of preventive detention to certain constitutional safeguards, upon the violation of which the individual could have a right to approach the Supreme Court or the High Courts, because the safeguards are fundamental rights for the enforcement of which the constitutional remedies would lie. There have been a number of cases in which the courts have nullified orders of the preventive detention in proceedings for habeas corpus. Secondly, the above provisions of the Constitution are not self-executory, but require a law to be made by the legislature conforming to the condition laid down in the article, and preventive detention can subsist only so long as a legislature permits. The Preventive Detention Act 1950 was thus passed by the Indian Parliament, which constituted the law of preventive detention in India. It was a temporary act, originally passed for only 1 year. Several times since then, the terms of the act was extended until it expired at the end of 1969. The revival of anarchist forces obliged Parliament to enact a new act named the Maintenance of Internal Security Act, popularly known as MISA, in 1971, having provisions broadly similar to those of the Preventive Detention Act of 1950. In 1974, Parliament passed the Conservative of Foreign Exchange and Prevention of Smuggling Act 1974, commonly referred to as COFEPOSA, as an economic adjunct of the MISA. While the MISA was in general aimed at subversive activities, the COFEPOSA is aimed at anti-social activities like smuggling, racketing in foreign exchange, and the like. MISA was repealed in 1978, but COFEPOSA still remains. Further, power of preventive detention has been conferred on the central and state governments to safeguard defense and security of the country and to maintain public order and essential supplies and services by enacting the National Security Act 1980 and the Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. With the increase in terrorist activities, the government had to pass in 1985 the Terrorist and Disruptive Activities Act 1985, commonly known as TADA. This has widely been used to curb terrorism. It may be mentioned that the number of detainees during the emergency of 1975-76 had soared up to 1,75,000. On the eve of coming to power, the Janata Party promised to abolish detention without trial. After coming to power, the Janata government came to realize the reality of the problem. Eventually, in April 1978, the MISA was repealed by Parliament, but the government refused to repeal the COPEPOSA because while the former related to political detention, the latter was aimed at social offences which required extra power to check when inflation, black marketing, smuggling and like were rampant. The provision in clause 2 to 7 of Article 22 could not be altogether omitted. So long as preventive detention was authorized COPEPOSA, the Janata government therefore sought to alleviate the rigors of the procedure for preventive detention by effecting changes in clause 4 and 7 by enacting the Constitution 44th Amendment Act 1978. But the relevant provisions of this Amendment Act could not be brought into effect immediately since some changes in the machinery of the advisory boards had to be made. Hence, the Amendment Act of 1978 empowered the central government to bring into force these provisions by issuing notifications. Paradoxically, however, before any such notification could be issued, the Janata government had its fall and Mrs. Gandhi returned to power in January 1980. The government has not issued any such notification with notwithstanding adverse comments by the Supreme Court in view of the inordinate delay in the result. The original clauses relating to the preventive detention in Article 22 subsist still today, and the relevant provisions of the Amendment Act of 1978 solemnly passed by the Parliament remain a dead letter. Some states, as for example Jammu and Kashmir and Madhya Pradesh, have enacted state laws authorizing preventive detention which recall the old Preventive Detention Act of 1950. It should be pointed out in this context that the legislative power to enact law of preventive detention is divided by the Constitution between the Union and the states. The Union has exclusive power only when such law is required for regions connected with defense, foreign affairs or security of India. A state has power concurrently with the Union to provide the preventive detention for regions connected with security of the state, maintenance of public order or the maintenance of supplies and services essential to the community. A state has therefore a say in the matter of abolishing preventive detention on these grounds because it is the responsibility of the state to maintain public order. Entry 1 of list 2, production, supply and distribution of goods. So long as the concurrent power of the states to legislate for preventive detention with respect to the aforesaid grounds remains, and any of them feels the need for retaining or making state laws for preventive detention, it is practically difficult for the Union government to impose its will on such states. Till then, the existence of Article 22 on the Constitution will be beneficial rather than prejudicial to the abuse of liberty, because the validity of such state laws can be challenged on the ground of contravention of the safeguards laid down in Article 22. In these circumstances, Article 22 continues to be the Constitution as the necessary evil, as an adjunct to the guarantee of personal liberty and the prohibition against discrimination. Our Constitution lays down certain provisions to prevent exploitation of the weaker section of the society by unscrupulous individuals or even by the state. Article 23 says traffic in human beings and beggar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offense punishable in accordance with law. Nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service the state shall not make any discrimination on grounds only of religion, race, caste or class or any of them. Slavery in its ancient form may not so much be a problem in every state today, but its newer forms, which are labeled in the Indian Constitution under the general term exploitation, are no less a serious challenge to human freedom and civilization. It is in this view that our Constitution, instead of using the word slavery, uses the more comprehensive expression traffic in human beings, which includes a prohibition not only of slavery but also of traffic in women or children or the crippled for immoral or other purposes. Our Constitution also prohibits forced labor of any form, which is similar to beggar, an indigenous system under which landlords sometimes used to compel their tenants to render free service. What is prohibited by the clause is therefore the act of compelling a person to render gratuitous service where he was lawfully entitled either not to work or to receive remuneration for it. The clause therefore does not prohibit forced labor as punishment for a criminal offense, nor would it prevent the state from imposing compulsory recruitment or conscription for public purposes such as military or even social service. Article 23 has an element of force. Special provision for the protection of children is made in Article 24, which says no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. It is to be noted that prohibition imposed by this article is absolute and does not admit of any exception for the employment of a child in a factory or mine or in any other hazardous employment. As for example, in a railway or a port, Supreme Court directed that children should not be employed in hazardous jobs in factories, and positive steps should be taken for the welfare of such children as well as improving the quality of their life. And the employers of the children below 14 years must comply with the provisions of Child Labor Prohibition and Regulation Act, providing for compensation employment of their parents, guardians and their education. India under the Constitution is a secular state, that is, a state which observes an attitude of neutrality and impartiality towards all religions. A secular state is founded on the idea that the state is concerned with the relation between man and not with the relation between man and God, which is the matter for individual conscience. The attitude of impartiality towards all religions is secured by the Constitution by several provisions, Article 25 to 28. Firstly, there shall be no state religion in India. The state will neither establish a religion of its own nor confer any special patronage upon any particular religion. It follows from this that the state will not compel any citizen to pay any taxes for the promotion or maintenance of any particular religion or religious institution. No religious instruction shall be provided in any educational educational institution wholly provided by state funds. Even though religious instruction be imparted in educational institution recognized by or receiving aid from the state, no person attending such institutions shall be compelled to receive the religious instruction without the consent of himself or of his guardian, in case the pupil be minor. In short, while regular instruction is totally banned in state-owned educational institutions, in other denominational institutions it is not totally prohibited, but it must not be imposed upon people of other religions without their consent. Secondly, every person is guaranteed the freedom of conscience and the freedom to profess, practice, and propagate his own religion, subject only to restrictions imposed by the states in the interests of public order, morality, and health, so that the freedom of religion may not be abused to commit crimes or antisocial acts, as for example to commit the practice of infanticide and the like. To regulations or restrictions made by the state relating to any economic, financial, political, or other secular activities which may be associated with religious practice but do not really appertain to the freedom of conscience. To measures for social reform and for throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Subject to the above limitations, a person in India shall have the right not only to entertain any religious belief but also to practice the observances dictated by such belief and to preach his views to others. Thirdly, not only is there the freedom of the individual to profess, practice, and propagate his religion, there is also the right guaranteed to every religious groups or denominations to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. To those who have any idea as to what part religion plays in the entire being of the common man in India, the bold pronouncement in the above article must appear to be astoundingly progressive, or more so if we consider that while the other half of the truncated territory consisting of a large mass of Hindu minority has adopted Islam as the state religion in her constitution, India stands firm regardless of her environments. It is to be noted that this guarantee is available not only to the citizens of India but to all persons including aliens. The ambit of the freedom of religion guaranteed by Article 25 to 26 has been widened by the judicial interpretation that what is guaranteed by the Article 26 and 25 and 26 is the right of the individual to practice and propagate not only matters of faith or belief but also all those rituals and observances which are regarded as integral parts of the religion by followers of its doctrines. Of course, religion is a matter of faith, but it is not necessarily theistic, and there are well-known religions in India like Buddhism and Jainism which do not believe in God. On the other hand, though a religion undoubtedly has its basis in the system of beliefs or doctrines which are regarded by those who profess that religion as conducive to their spiritual well-being, it would not be correct to say that religion is nothing else but a doctrine of belief. Similarly, each religion, denominations, or organization enjoys complete autonomy in the matter of deciding as to what rites and ceremonies are essential according to the tenets of religion they hold. Regulation by the state again cannot interfere with things which are essentially religious, but the court has the right to determine whether a particular rite or observance is regarded as essential by the tenets of a particular religion, and to interfere if a particular practice offends against public health or morality, or not being an essentially religious practice contravenes any law of social, economic, and political regulation. It should be pointed out in this context that the word secular is a dubious word capable of diverse meanings, and one of its dictionary meaning is concerned with the affairs of the world as opposed to religious affairs. This has not only caused confusion amongst teachers of political science and law in India, but has also been taken advantage of by interested parties. This state of confusion has been set at rest by authoritative pronouncement made by the Supreme Court in a 9-judge decision as follows. Secularism in India does not mean that the state should be hostile to religion, but that it should be neutral as between the different religions. Every individual has the freedom to profess and practice his own religion, and it cannot be contended that if a person is a devout Hindu or a devout Muslim, he ceases to be secular. The use of the vague word secular in the preamble would not be override the enacted provisions of in Article 20 to 30 or Article 351, so that the preference of Sanskrit in the academic syllabus as an elective subject while not considering this status to Arabic or Persian or the like would not militate against the basic tenets of secularism. The neutrality of the state would be violated if religion is used for political purposes and advocated by the political parties for their political ends. An appeal to the electorate on ground of religion offends secular democracy. Politics and religion cannot be mixed. If a state government does this, it will be a fit case for application of 356 and of the Constitution against it. It is in this sense that secularism is to be regarded as a basic feature of the Constitution. It is amazing that some Christian leaders assert that the word propagate in Article 25(1) gives them a fundamental right to convert people of other faiths into Christianity by any means. This assertion, followed by agitation, is particularly amazing because it seeks to undermine the decision of the Supreme Court in Stanislaus case in January 1977, which had been brought by a Christian father who sought to invalidate a Madhya Pradesh Act because it made it a penal offense to convert or to attempt to convert a person by means of force, fraud, or allurement. Odisha had earlier passed a similar act which used the word inducement in place of allurement, and the constitutionality of that act had been challenged by several members of the Christian community, including a Christian society, a professor of geology, and several priests. Both the acts were taken up together by the Supreme Court, and the contentions of the Christian community were rejected in toto by Supreme Court, laying down the following propositions of law which are under the Constitution binding upon all courts in India. The right to propagate in Article 25(1) gives to each member of the early religion and right to spread or disseminate the tenets of his religion religion, say by advocacy or preaching, but it would not include the right to convert another, because each man has the same freedom of conscience guaranteed by that very provision on which the Christian relied. The equal freedom of conscience belonging to each man under Article 25(1) means that he has the freedom to choose and hold any faith of his choice and not to be converted into another religion by means of force, fraud, inducement, or allurement. He can, of course, voluntarily adopt another religion, but force, fraud, inducement, and allurement takes away the free consent from the would-be convert. Even assuming that a particular religion had the right to propagate its tenets by any means, including conversion, the state has the right and duty to intervene if such activity of conversion offended against public order, morality, or health. Because the guarantee of freedom of religion in Article 25(1) is subject to limitation of public order, morality, or health as follows. 25(1) subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. If any such right to convert we considered, such right would belong to every citizen, so that there would be inevitably a breach of public peace if every religion community carried on to campaign to convert people belonging to other faiths. By the use of force, fraud, inducement, or allurement, the state was therefore constitutionally authorized, nay, enjoined to maintain public order by prohibiting and penalizing conversion, including attempt to convert. If force, fraud, inducement, or allurement was used by the person or person advocating conversion in any particular case, this is exactly what had been done by the MP and Orissa Acts. The Supreme Court therefore upheld the constitutional validity of both the MP and Orissa Act after rejecting every plea raised on behalf of the Christian parties. After this pronouncement of the Supreme Court, the Arunachal Pradesh legislature passed a bill modeled exactly on the MP and Orissa Act, which had been held to be valid by the Supreme Court, and submitted it to the President for its assent. A private member of Parliament, Sri O.P. Tyagi, presented before the Lok Sabha a similar bill, which, if passed by Parliament, would be applicable to all states of India. The Christian community at once started agitation and demonstration against these two bills, with threats against severer resistance if these measures were passed. They politicized the issue with the slogan that it was a campaign against Christian religion. In particular, this contention involves suppression of truth on the following points. Neither of the disputed bills was labeled against the Christian religion as such, but would have operated against any religious community, including the Hindu, Muslim, Sikh, etc., which resorted to any of these unlawful means, force, fraud, inducement, or allurement, in order to convert a member of another faith to its own fold. That all the legal points now raised against these two pending bills were taken by the Christian parties to the Madhya Pradesh and Odisha Acts case, but were definitely rejected by the Supreme Court. Those who rely on the international charters in support of their freedom to convert have not mentioned Article 18(2) of the International Covenants on Civil and Political Rights 1966, which says no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. Yesterday I have talked about no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. This freedom of every man to adopt a religion of his choice is guaranteed by Clause 1 of Article 18. The two clauses read together mean that every individual shall have the freedom to choose his own religion or belief in worship, and this freedom shall not be impaired by the use of coercion by any individual attempting to induce him to adopt another religion. So far as the disputed Indian bills ban the use of force as a means of conversion, it is perfectly in line with the international charter. When fraud is used, the freedom of choice of individuals sought to be converted is similarly impaired. The only dispute which may possibly be raised by the Indian Christians is as to the use of inducement or allurement, but such means to impair the freedom of choice of an individual and his resultant choice or volition cannot be said to be free within the meaning of Article 18.1 of the international covenants referred to. The validity of use of these two words in an Indian bill would rest not on the wording of the international covenants, which is the resultant of various international factors, but on the interpretation of the word public order and morality in Article 25.1 of our Constitution, which constitutes the supreme law of this land. If the agitators were dissatisfied with Supreme Court's interpretation of Article 25.1, they were free to challenge the constitutionality of the provisions of the disputed bills after they were passed, and to persuade the judges of the Supreme Court to revise their views as expressed in the Stanislaus case. But there was not the least justification to denounce the bill as a crusade against the Christians in particular, when they were nothing but a codification of the principles laid down by the highest tribunal of the land and on the model of the state statutes which had been approved by that tribunal in the Stanislaus case. Apart from foregoing guarantee of freedom of conscience and religion, there are certain general provisions which are aimed at ensuring the effectiveness of the above guarantee by prohibiting any discrimination by the state on the ground of religion alone. The state shall not discriminate against a citizen in any matter, Article 15.1, and in particular in the matter of employment, Article 16.2, only upon the ground of religion. Similar discrimination is banned as regards access to or use of public places, Article 15.2. Admission into any educational institution maintained or aided by the state, Article 29.2. The right to vote, Article 325. Where the religious community is in the minority, the Constitution goes further to enable it to preserve its culture and religious interest by providing that, Article 29, the state shall not impose upon it any culture other than the community's own culture, Article 29.1. Such communities shall have the right to establish and administer educational institutions of its choice, and states shall not, in granting aid to educational institutions, discriminate against such an educational institution maintained by a minority community on the ground that it is under the management of a religious community, Article 30. Full compensation has to be paid if the state seeks to acquire the property of a minority educational institution, Article 30(1)(a). The sum total of the above provisions make our state more secular than even the United States of America. The secular nature of our Constitution has been further highlighted by inserting this word in the preamble by the Constitution 42nd Amendment Act 1976. A word of caution should, however, be uttered in this context. What is meant by secularism or the safeguards of the minority are exhaustively enumerated in Article 25 to 30 and allied provisions as to minority rights. See further under Chapter 29 post. If the minority community presses for any extra favors outside these specific provisions in the name of secularism, or the party in power yields them for political reasons, it might be reintroducing those vices of communalism from which India suffered so much during the later British regime, and which the fathers of the Constitution eliminated from the Constitution of Free India, as for example, communal representation in the legislatures or communal reservation in public employment. For instance, if government seeks to justify an appointment to a public office, high or low, not on the ground of merit but on the ground that the appointee belongs to a religious minority, such discrimination would violate the fundamental rights of any other community under Article 16(2) not to be discriminated against on the ground of religion or the like. Instead of safeguarding the rights of a minority community, it would deny the rights of majority and other minority communities which are guaranteed by the Constitution itself. Neither secularism nor minority rights can therefore be allowed to be an argument for preference of the minority or to undermine the national unity and strength, for which the confidence of the majority is no less necessary, but a minority educational institution has the power to reserve only up to 50% seats for students belonging to its own community. The preamble of our Constitution aims at securing the unity and integrity of the nation. Religious and cultural safeguards have been guaranteed by the Constitution to minority communities in order to ensure them justice, freedom of thought, expression, belief, faith, and worship. But if any minority community goes on clamoring for more than what the framers of the Constitution offered to them, it would simply perpetuate the insular objective of these communities, and India would never grow up into a nation. Inspired with the ideals of unity and integrity of the nation, to revert to the anti-independence vortex of communalism and separatism would imperil the very foundation of independence. On the other hand, secularism, which means neutrality of the state towards all religions, will itself be violated if government suppresses the religious or other legal rights of majority community to appease the demands of an aggressive minority. The Constitution of 1949 had a threefold provision for safeguarding the right of private property. It is not only guaranteed the right of private ownership, but also the right to enjoy and dispose of property free from restrictions other than reasonable restrictions. Firstly, it guaranteed to every citizen the right to acquire any property by a lawful means such as inheritance, personal earning, or otherwise, to hold it as his own and to dispose it freely, limited only by reasonable restrictions to serve the exigencies of public welfare, and B, by any other reasonable restrictions that may be imposed by the state to protect the interests of any scheduled tribes. Article 19(1)(f). The restrictions must, of course, be reasonable from the substantive as well as procedural standpoints. Thus, the restriction must not be an excess of the requirement of the interest of the general public for which the restriction is sought to be imposed. A restriction would be procedurally unreasonable if In the absence of extraordinary circumstances, it is imposed without notice or without hearing or without assigning any reason on the subjective satisfaction of an administrative authority. Secondly, the Constitution guaranteed that no person shall be deprived of his property save by the authority of law, Article 31(1). This implied that, short of the consent of the owner, a man's property can be taken only by the consent of the nation as embodied in the laws passed according to the Constitution. Any property which is seized to be seized by the police or the government without proper legal authority will be released at the intervention of the courts. As against its own subjects, a sovereign cannot exercise an act of state, and the private property of a subject cannot be taken away by the executive order, distinguished from an order made in exercise of power conferred by the statute. This clause was intended to be a protection against executive but not against legislative appropriation of property. The Supreme Court, however, held that the law which seeks to deprive a person of his property must be a valid law, which means a law enacted by the competent legislature and not inconsistent with any of the fundamental rights guaranteed by Part 3 of the Constitution. Thirdly, the Constitution enjoined that if the state wants to acquire the private property of an individual or to requisition, that is, to take over its possession for the temporary period, it could do so only on two conditions: that the acquisition or requisitioning is for a public purpose, that when such a law is passed, it must provide for payment of an amount to the owner, either by fixing the amount or by specifying the principle upon which it is to be determined and given. Article 31(2). The provisions of the Constitution as to the obligation to pay compensation for acquisition of property for public purposes, however, underwent serious changes as a result of amendments of the Constitution by the 1st, the 4th, the 17th, the 25th, and the 42nd Amendment Act. The net result of these amendments is as follows. A. Though the legislature was under the constitutional obligation to pay compensation, the adequacy of the compensation shall not be liable to be questioned in the court of law. In other words, when a law provided for the acquisition of person's property for a public purpose, he would not be entitled to challenge the validity of that law in a court of law on the ground that the legislature had not provided for payment of the full value of his property. This Fourth Amendment 1955 in Article 31(2) was necessitated by the fact that even the word compensation simpliciter was interpreted by the Supreme Court as implying full compensation, that is, the market value of the property at the date of the acquisition. The government thought that it was not practicable to implement its program of national planning and development if the full market value was to be paid from the inadequate resources of the infant republic for every inch of the property which was to be nationalized. But even after the foregoing amendment, the Supreme Court continued to hold that the very word compensation implied full monetary equivalent of the property taken away from the owner, that is, its market value at the date of the acquisition. By the 25th Amendment of 1971, therefore, the word compensation in Clause 2 of Article 31 was substituted by the word amount, but again the majority of Supreme Court reserved an area for judicial intervention in the full bench case of Keswanand versus State of Kerala, by holding that the amount which was fixed by the legislature could not be arbitrary or illusory. degree, but must be determined by a principle which is relevant to the acquisition of property. The Indira government reacted by putting special laws in acquisition beyond the pale of Article 31 altogether by engrafting the exceptions in Article 31A to 31D, which will be mentioned presently. By a number of successive amendments, certain exceptions to Article 31(2) were introduced in Article 31A to 31D to exclude the obligation to pay any amount as compensation in the case of laws providing for acquisition by the state or nationalization if such laws relate to matters specified in these exceptional provisions. These exceptions to the obligations under Article 31 may now be examined in particular. Article 31A relates to a law for acquisition by the state of any state or other intermediate interest in land. The object of taking out the acquisition of intermediate interests in land from the obligations to pay compensation was to make it possible for the government to effect agrarian reform, which was so urgently needed to protect the interests of the tenants as well as to improve the agricultural wealth of the country. In order to facilitate agrarian reforms as well as social control of the means of production, it has been provided in Article 31A that not only a law providing for the acquisition by the state of any state or of any rights therein or the extinguishment or modification of any such rights, but also certain other laws which as a law providing for the taking over of the management of any property by the state for a limited period, either in the public interest or in order to secure the proper management of the property, shall be constitutionally violated even though it takes away or abuses any of the rights conferred by Article 14 and 19. While Article 31A accepts certain classes of laws, Article 31B read with the 9th schedule gives a blanket cover to particular enactments which are for the time being specified in the 9th schedule. Their number in 2000 is 284. They have been altogether immunized from attack on the ground of contravention of any of the fundamental rights. Article 31C, as inserted by the 25th Amendment Act 1971, provided that any law which seeks to implement the directive in Article 39B or 39C, that is the plan of socialistic distribution of wealth and the means of production, shall not be void for inconsistency with Article 14 or 19. But the effectiveness of Article 31C was crippled by the decision of the majority of the Supreme Court in the case of Kesavanand that judicial review is one of the essential features of the Indian Constitution which cannot be taken away by process of amendment under Article 368, and that accordingly that part of Article 31C which stated that any legislative declaration that a particular law was made to implement the directives in Article 39 BC shall not be open to question in a court is itself unconstitutional. Undaunted by Kesavananda, Parliament enlarged the scope of 31C by the 42nd Amendment Act 1976 by including within its protection any law to implement any of the directive principles enumerated in Part 4 of the Constitution, not merely in Article 39B to C. As a result of this, if any law of acquisition was made with the object of giving effect to any of the directives, the reasonableness of such a law cannot be questioned under Article 14 or 19. Minerva Wills has, however, nullified this extension. The last fagot of exception, Article 31D, has been repealed by the 43rd Constitution Amendment Act 1977 and need not bother the reader. While the Congress government for over a quarter of a century had eaten taken into the vitals of Article 31(2) by successive amendments as outlined above, it was left to the Janata government to eliminate the right of property altogether from the list of fundamental rights in Part 3. This has been effected by the 44th Amendment Act 1978, which we have already discussed in connection with judicial review. Nevertheless, its incidents may be recapitulated in order to give a definite idea as to how much of the rights to property remain under the Indian Constitution after April 1979 and in what shape. Article 19(1)(f) has been repealed. Article 31(1) has been taken out of Part 3 and made a separate article, which 300A, which reads as follows: no person shall be deprived of his property save by authority of law. The result, in short, is that if an individual's property is taken away by a public official without legal authority or in excess of power conferred by law in this behalf, he can no longer have speedy remedy direct from the Supreme Court under Article 32, because the right under Article 300A is not a fundamental right. He shall have to find his remedy from the High Court under Article 226 or by an ordinary suit. Clause 2A(6) of Article 31 has been omitted. Clause 2 of Article 31 has been omitted, but its proviso has been transferred to Article 30 as Clause 1A to the article. Though Article 31 itself has been deleted, Article 31A, which was originally inserted as an exception to Article 31, has been retained with the omission of any reference to Article 31. Article 31A therefore remains to operate as an exception to Article 14 and 19 to shield the 5 classes of laws specified in Article 31A. Curiously, however, the second proviso to Article 31A(1) has been retained, giving the right to full compensation to the actual tiller, even though Article 31 has been omitted and a reference to Article 31 has been omitted. Clause 1 to Article 31A, to which the second proviso operates as an exception. The above patchwork is bound to create confusion in the mind of a lay reader. It would accordingly be profitable to outline the vestiges of the right to compensation which survive the onslaught of the 44th Amendment. These are twofold. Though the mass of citizens shall no longer have any guaranteed right to compensation if his property is acquired or requisitioned, and the legislature shall have no constitutional obligation to provide for payment of any solatium to the expropriated owner, 2 exceptions of this general position are followed by 44th Amendment in 2 cases of acquisitions. If the property acquired belongs to an educational institution established and administered by a minority, the law of acquisition must provide it for such compensation as would not abrogate the right of the minority to establish and administer educational institution, which is guaranteed by Article 31 Sworn of innuendo. This means that if the state chooses to acquire a minority educational institution, it must offer full market value or adequate compensation so that minority community may set up that institution at a suitable alternative site. If the state seeks to acquire the land which is personally cultivated by the owner and such land does not exceed the statutory ceiling, the state must pay to such owner full market value of his land as well as any building or structure standing thereon or appurtenant thereto. Though both the foregoing exceptions may be beneficial so far as they go, there is much to comment from the standpoint of constitutional law as from the national standpoint. As regards to the concession in favor of a minority educational institution, it is somewhat inexplicable why no such guarantee should be made in favor of the educational institution managed by members of a majority community. It is not education is pure and adorable, whether it comes through the Ganges or the Jordan. In their overzealousness for the addition of a special guarantee in favor of the minority, which the fathers of the original constitution did not envisage, the fathers of the 44th Amendment took no time to ponder that by eliminating Article 31(2), they were taking away a right which had been guaranteed to all persons in India. Legally speaking, the new provisions in Article 31A is a tale which has lost its head by the repeal of Article 31(2). As to the right of a small tiller of land to full compensation for his land and building or other structures, one fails to understand why similar right should not be guaranteed to a poorer man who has not an inch of agricultural land but has a humble hut to lay his head at night. He may be a day laborer, a petty pensioner, or a landless peasant who tills another man's land. Are they less deserving? Would it be pertinent to point out in this context that even in the 1977 Constitution of the USSR, there was Article 13 which stated, the personal property of citizens of the USSR may include articles of everyday use, personal consumption and convenience, the implements and other objects of small holding or for building an individual dwelling. The personal property of citizens and the right to inherit it are protected by the state. In short, in USSR, every individual had the guaranteed right to hold and inherit a dwelling irrespective of his being an agriculturist, and the duty of the state to protect this right would obviously mean that the state cannot acquire or deprive the owner of his dwelling house unless otherwise provided by the Constitution. The overzealous political leaders of India should know that the provision in 1982 Constitution of the Chinese Republic too is in the same strain. Though Article 6 provides for social ownership of the means of production, Article 13 at the same time guarantees to the individual to own personal property acquired by his personal income. The state protects the right of citizen to own lawfully earned income, savings, horses and other lawful property. Article 39 further declares as a fundamental right that the citizens' homes are inviolable. The net result of the foregoing provision seems to be that the state cannot take away an individual's dwelling house and similar personal property even by legislation, so that no question of compensation for compulsory acquisition may arise. In view of the drastic effects of the abolition of Article 19(1)(f) and 31(2), some jurists in India have put forth their belief that the Supreme Court would come to the rescue of the expropriated owners by holding that, notwithstanding the omission of such constitutionally guaranteed right to compensation, the court would derive such right from the legislative power contained in entry 42 of list 3, acquisition and requisitioning of property, read with the common law doctrine of eminent domain. Unfortunately, it has been possible for the author to persuade himself to this anachronistic assumption for reasons which have been elaborately given in the author's bigger work. In the circumstances, there is a case for restoration of some relief for the poorer sections of property owners as distinguished from capitalists or owners of the means of production, but such relief can be more easily brought about by further amendment of the Constitution than leaving it to the off chances of judicial amendment. Abstract declarations of fundamental rights in the Constitution are useless unless there is the means to make them effective. Constitutional experience in all countries shows that the reality of the existence of such rights is tested only in the courts. The power of the courts to enforce obedience to the fundamental rights again depends not only upon the impartiality and independence of the judiciary but also upon the effectiveness of the instruments available to it to compel such obedience against the executive or any other authority. Under the Anglo-American system, such means have been found in the writs or judicial processes such as habeas corpus, mandamus, prohibition, certiorari, and quo warranto. The Indian Constitution lays down the following provisions for the enforcement of the fundamental rights guaranteed by the Constitution in the right of the above experience. The fundamental rights are guaranteed by the Constitution not only against the action of the executive but also against that of the legislature. Any act of the executive or of the legislature which takes away or abuses any of these rights shall be void, and the courts are empowered to declare it as void. Article 13. The Supreme Court strikes at the arbitrary action of the state. It has jurisdiction to enforce the fundamental rights against private bodies and individuals and award compensation for violation of the fundamental rights. It can exercise its jurisdiction suo motu or on the basis of appeal. Apart from the power to treat a law as void for being in contravention of the provisions of the Constitution guaranteeing the fundamental rights, the judiciary has been armed with the power to issue the writs mentioned above, habeas corpus, etc., in order that it may enforce such rights against any authority in the state at the instance of an individual whose rights has been violated. The power to issue these writs for the enforcement of the fundamental rights is given by the Constitution to the Supreme Court and High Courts. Article 32 and 226. The rights so guaranteed shall be suspended except during a proclamation of emergency in the manner laid down by the Constitution. Article 359. Though a fundamental right may be enforced by other proceedings such as declaratory suit under the ordinary law or an application under Article 26 or by way of defense to legal proceeding brought against an individual, a proceeding under Article 32 is described by the Constitution as a constitutional remedy for the enforcement of the fundamental rights included in Part 3, and the right to bring such proceeding before the Supreme Court is itself a fundamental right in Part 3. Article 32 is the cornerstone of the entire edifice set up by the Constitution. Commenting on this article in the Constituent Assembly, Dr. Ambedkar said, "If I was asked to name any particular article in the Constitution as the most important, an article without which this Constitution would be a nullity, I would not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it. The relevant provisions in Clause 1 and 2 of Article 32 should be noticed. The right to move the Supreme Court by appropriate proceeding for the enforcement of rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part." Article 32 thus provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right, being included in Part 3. The Supreme Court is thus constituted the protector or guarantor of fundamental rights, and it cannot, consistently with the responsibility so laid on it, refuse to entertain applications seeking protection against infringement of such right on technical grounds. Thus, through a writ may ordinarily be refused on the ground that the petitioner has another adequate legal remedy open to him. Application under Article 32 cannot be refused merely on the ground where a fundamental right appears to have been infringed. The Supreme Court can make any order appropriate to the circumstances, unfettered by the technicalities of English prerogative writs. On the other hand, the sole objective of Article 32 is the enforcement of the fundamental rights guaranteed by the Constitution. Whatever other remedies may be open to the person aggrieved, he has no right to complain under Article 32. Where no fundamental right has been infringed, for the same reason, no question other than relating to a fundamental rights will be determined in a proceeding under Article 32. The expression prerogative writ is one of English common law which refers to the extraordinary writs granted by the sovereign, a fountain of justice on the ground of inadequacy of ordinary legal remedies. In course of time, these writs came to be issued by the High Court of Justice as the agency through which the sovereign exercised his judicial powers, and these prerogative writs were issued as extraordinary remedies in cases where there was either no remedy available under the ordinary law or the remedy available was inadequate. These writs are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. In the sense, the power of high courts to issue these writs is wider than that of the Supreme Court, inasmuch as under 32 of the Constitution, the Supreme Court has the power to issue these writs only for the purpose of enforcement of fundamental rights, whereas under Article 26, a High Court can issue these writs not only for the purpose of enforcement of fundamental rights, but also for the redress of any other injury or illegality owing to contravention of the ordinary law, provided certain conditions as satisfied, for which see Chapter 20, Post 161. Thus, an application to the High Court under Article 226 will lie not only for the fundamental right has been infringed, but also where some other limitation imposed by the Constitution outside Part 3 has been violated, as for example, where the state legislature has imposed a sales tax in contravention of the limitations imposed by the Article 286, but an application under Article 32 shall not lie in any case unless the right infringed is fundamental right enumerated in Part 3 of the Constitution. Another point of distinction between the two jurisdictions is that while the Supreme Court can issue a writ against any person or government within the territory of India, a High Court can under Article 226 issue a writ against any person, government, or other authority only if such person, government, or authority is physically resident or located within the territorial jurisdiction of the High Court, that is, within the state or which the territorial jurisdiction of the particular High Court extends, or if the cause of action arises within such jurisdiction. As stated earlier, the Supreme Court has been assigned by the Constitution a special role as the protector and guarantor of the fundamental rights. Where therefore the infringement of the fundamental rights has been established, the Supreme Court cannot refuse relief under Article 32 on the ground that the aggrieved person may have his remedy from some other court or under the ordinary law. that disputed facts have to be investigated or evidence has to be taken before relief may be taken to the petitioner, that the petitioner has not asked for the proper writ applicable to his case. In such a case, the Supreme Court must grant him the proper writ and, if necessary, modify it to suit the exigencies of the case. Generally, only the person affected may move the court, but the Supreme Court has held that in social or public interest actions, any person may move the court. This is called expansion of the rights to be heard. It favors public interest litigation. Following English and American decisions, the Supreme Court has admitted exceptions from the strict rules relating to affidavit locus standi and the like of the case of a class of litigation classified as public interest litigation, that is, where the public in general are interested in the vindication of some rights or the enforcement of some public duty. Another consequence which results from the guarantee of the constitutional remedy under Article 32 is this: not only this remedy immune from being overridden by legislation, but any law which renders nugatory or illusory the Supreme Court's power to grant this remedy shall be void. This was illustrated in the leading case of Gopalan versus State of Madras, where the Supreme Court invalidated Section 14 of the Preventive Detention Act 1950, and it originally stood. The section was as follows: no court shall, except for the purpose of prosecution for an offense punishable under subsection 2, allow any statement to be made or any evidence to be given before it, or the substance of any communication made under section 7 of the grounds on which the detention order has been made against any person, or of any representation made by him against such order. And notwithstanding anything contained in any other law, no court shall be entitled to require any public officer to produce before it or to disclose the substance of any such communication or representation made, or the proceedings of an advisory board, or that part of the report of an advisory board which is confidential. It shall be an offense punishable with imprisonment for a term which may extend to 1 year, or with fine, or with both, for any person to disclose or publish without the previous authorization of the central government or the state government, as the case may be, any contents or matter purporting to be contents of any such communication or representation as referred to in subsection 1. The Supreme Court struck down the above provision on the ground that it contravenes Article 32 by way of preventing the Supreme Court from effectively exercising powers under Article 32. The observations made by the Justice Mahajan regarding Article 32 of our constitutions are illuminating. This section is in the nature of an iron curtain around the acts of the authority making the order of preventive detention. The Constitution has guaranteed to the detained person the right to be told the grounds of detention. He has been given a right to make a representation by Article 22 sub Article 5, yet Section 14 prohibits the disclosure of the grounds furnished to him or the contents of the representation made by him in a court of law, and makes a breach of this injunction punishable with imprisonment. Now it is clear that if an authority passes an order of preventive detention for reasons not connected with any of the 6 subjects mentioned in the 7th schedule, this court can always declare the detention illegal and release the detainee. But it is not possible for this court to function if there is a prohibition against disclosing the grounds which have been served upon him. It is only by an examination of the grounds that it is possible to say whether the grounds fall within the ambit of a legislative power contained in the Constitution or are outside its scope. Again, something may be served on the detainee as being grounds which are not grounds at all. In this contingency, it is the right of the detained person under Article 32 to move this court for enforcing the right under Article 25(2) that he be given the legal grounds on which detention order is based. This court would be disabled from exercising its function under Article 32 and adjudicating on the point that the grounds given satisfy the requirements of the subclause if it is not open to it to see the grounds that have been furnished. It is guaranteed right of the person detained to have the very grounds which are the basis of the order of detention. This court would be entitled to examine the matter and to see whether the grounds furnished are the grounds on the basis of which he has been detained or by contain some other vague or irrelevant material. The whole purpose of furnishing a detained person with the grounds is to enable him to make a representation refuting these grounds of providing his innocence. In order that this court may be able to safeguard this fundamental right and to grant him relief, it is absolutely essential that the detainee is not prohibited under penalty of punishment to disclose the grounds to the court, and no injunction by law can be issued to this court disabling it from having a look at the grounds. Section 14 creates a substantive offense if the grounds are disclosed, and it also lays a duty on the court not to permit the disclosure of such grounds. It virtually amounts to a suspension of a guaranteed right provided by the Constitution, inasmuch as it indirectly by a stringent provision makes administration of the law by this court impossible, and at the same time it deprives a detained person from obtaining justice from this court. In my opinion, therefore, this section, when it prohibits the disclosure of the grounds, contravenes or abridges the right given by Part 3 to a citizen and is ultra-vires the powers of the Parliament to the extent. There is provision in the Constitution for empowering courts other than Supreme Court or the High Courts to issue the writs by making a law of Parliament, but no such law has yet been passed, with the result that no courts other than the Supreme Court or High Court have got the power to issue these writs. The incidents of the several kinds of writs which our Supreme Court and High Court are authorized by the Constitution to issue now may now be noted. A writ of habeas corpus in the name of an order calling upon the person who has detained another to produce the letter before the court in order to let the court know on what ground he has been confined and to set him free if there is no legal justification for the imprisonment. The words habeas corpus literally means to have a body. By this writ, therefore, the court secures the body of a person who has been imprisoned to be brought before itself to obtain knowledge of the reason why he has been imprisoned and to set him free if there is no lawful justification for the imprisonment. The writ may be addressed to any person, whatever, an official or a private person who has another person in his custody, and disobedience to the writ is met with punishment for contempt of court. The writ of habeas corpus is thus a very powerful safeguard to the subject against arbitrary acts, not only of private individuals but also of the executive. Habeas corpus petition becomes infructuous if the detainee is produced before the magistrate. The different purposes for which the writ of habeas corpus is available may accordingly be stated as follows. For the enforcement of fundamental rights, It has already been explained that under our constitution, the right of personal liberty is guaranteed against the state by Article 21, which says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Hence, if the executive has arrested and detained any person without the authority of any law or in contravention of the procedure established by the law which authorizes the detention or the law which authorizes the imprisonment is itself invalid or unconstitutional, the High Court or the Supreme Court may issue a writ of habeas corpus against the authority which has kept the person in custody and order the release of the person under detention. It will also issue, where the order of imprisonment or detention is ultra vires, the statute which authorizes the imprisonment or detention. The writ of habeas corpus is, however, not issued in the following cases: where the person against whom the writ is issued on the person who is detained is not within the jurisdiction of the court. To secure the release of a person who has been imprisoned by a court of law or on a criminal charge. To interfere with a proceeding for contempt by a court of record or by parliament. Now, mandamus literally means a command. It demands some activity on the part of the body or person to whom it is addressed. In short, it commands the person to whom it is addressed to perform some public or quasi-public legal duty which he has refused to perform and the performance of which cannot be enforced by any other adequate legal remedy. It is therefore clear that mandamus will not issue unless the applicant has a legal right to the performance of the legal duty of a public nature, and the party against whom the writ is sought is bound to perform that duty. It is discretionary remedy, and the High Court may refuse to grant mandamus where there is an alternative remedy for redress of the injury complained of. In the matter of enforcement of fundamental rights, however, the question of alternative remedy does not weigh so much with the court, since it is the duty of the Supreme Court or the High Court to enforce the fundamental rights. In India, mandamus will lie not only against officers and other persons who are bound to do a public duty, but also against the government itself, for Article 226 and 361 provided that appropriate proceedings may be brought against the government concerned. The writ is also available against inferior courts or other judicial bodies which they have refused to exercise their jurisdiction and thus to perform their duty. The purpose for which a writ may be issued may now be analyzed as follows. For the enforcement of fundamental rights, whenever a public or officer or a government has done some act which violates the fundamental rights of a person, the court would issue a writ of mandamus against mandamus restraining the public officer or the government from enforcing that order or doing that act against the person whose fundamental rights has been infringed. Thus, where the petitioner who was otherwise eligible for appointment to the subordinate civil judicial service was not selected owing to the operation of a communal rotation order, which infringed the fundamental rights guaranteed to the petitioner by Article 16(1), the court issued an order directing the state of Madras to consider and dispose of the petitioner's application for the post after taking it on the file on its merit and without applying the rule of communal rotation. Apart from enforcement of fundamental rights, mandamus is available from a high court for various other purposes, as for example, to enforce the performance of a statutory body where a public officer has not a power conferred by the constitution or the statute. The court may issue a mandamus directing him to exercise the power in case he refuses to do it. The writ also writ will also lie to compel any person to perform his public duty where the duty is imposed by the constitution or a statute or a statutory instrument. To compel a court or judicial tribunal to exercise its jurisdiction when it has refused to exercise it. To direct a public official or a government not to enforce a law which is unconstitutional. Mandamus will not be granted against the following persons: the president or the governor of a state for the exercise and performance of the power and duties of his office, for any act done or purporting to be done by him in exercise and performance of those powers and duties. Mandamus does not lie against a private individual or a body, whether incorporated or not, except where the state is in collusion with such private party in matter of contravention of any provision of constitution or statute or a statutory instrument. The writ of prohibition is a writ issued by the Supreme Court or a High Court to an inferior court, forbidding the latter to continue proceeding therein in excess of its jurisdiction or to usurp a jurisdiction with which it is not legally vested. In other words, the object of the writ is to compel inferior courts to keep themselves within the limit of their jurisdiction. The writ of prohibition differs from the writ of mandamus in that while mandamus commands activity, prohibition commands inactivity. Further, while mandamus is available not only against judicial authorities but also against administrative authorities, prohibition as well as certiorari are issued only against judicial or quasi-judicial authorities. Hence, prohibition is not available against a public officer who is not vested with judicial functions where excess of jurisdiction is apparent on the face of the proceeding. A writ of prohibition is not a matter of discretion but may be had of right. In India, a writ of prohibition may be issued not only in cases of absence or excess of jurisdiction but also in cases where the court or tribunal assumes jurisdiction under a law which itself contravenes some fundamental right guaranteed by the Constitution. The Supreme Court can issue the writ only where a fundamental right is affected by reason of the jurisdictional defect in the proceedings. Though the prohibition and certiorari are both issued against courts or tribunals exercising judicial or quasi-judicial powers, certiorari is issued to quash the order or decision of the tribunal, while prohibition is issued to prohibit the tribunal from making the ultra vires order or decision. It follows, therefore, that while prohibition is available during the pendency of the proceeding and before the order is made, certiorari can be issued only after the order has been made. Now I shall talk about the certiorari. Certiorari is a type of writ which is preferred before the Honorable High Court or Supreme Court of India. Briefly speaking, therefore, while prohibition is available at an earlier stage, certiorari is available at a later stage. On similar grounds, the object of both is to secure that the jurisdiction of an inferior court or tribunal is properly exercised and that it does not usurp the jurisdiction which it does not possess. The conditions necessary for the issue of the writ of certiorari are: there should be a tribunal or officer having legal authority to determine questions affecting rights of subjects and having a duty to act judicially. Such tribunal or officer must have acted without jurisdiction or in excess of the legal authority vested in such quasi-judicial authority, or in contravention of the rules of natural justice, or there is an error apparent on the face of its record. The Supreme Court early took the view that the writ of certiorari would not issue against purely administrative action. It would issue only if state, the authority has a duty to proceed judicially. That is to say, to come to a decision after hearing the parties interested in the matter and without reference to any extraneous consideration. But later decisions have obliterated the distinction between administrative and quasi-judicial bodies. The current view is that even if the governing statute does not require that before making an order affecting an individual, he must be heard, such a requirement would be implied by the court where the right of property or some other civil rights of the individual is affected. To omit to do this is to deny natural justice, and in such cases the court may quash the so-called administrative decision by means of a writ of certiorari under Article 226. A tribunal may be said to act without jurisdiction in any of the following circumstances: where the court is not properly constituted, that is to say, where persons who are not qualified to sit on the tribunal have sat on it and pronounced the decision complained against; where the subject matter of inquiry is beyond the scope of the tribunal according to the law which created it; where the court has assumed a jurisdiction on the basis of a wrong decision of facts upon the existence of which the jurisdiction of the tribunal depends; where there has been a failure of justice either because the tribunal has violated the principle of natural justice or because its decision has been obtained by fraud, collusion, and corruption; when the decision of an inferior tribunal is vitiated by an error apparent on the face of the record, it is liable to be quashed by certiorari even though the court may have acted within its jurisdiction. Error in this context means error of law, where the tribunal states on the face of the order the grounds on which they made it, and it appears that in law these grounds were not such as to warrant the decision to which they had come. Certiorari would issue to quash the decision. In all such cases, a high court can issue a writ of certiorari to quash the decision of the inferior tribunal, and the Supreme Court can also issue the writ in such cases provided some fundamental rights has also been infringed by the order complained against. Today I shall talk about a type of writ which is called quo warranto. Quo warranto is a proceeding whereby the court requires into the legality of the claim which a party asserts to a public office, and to oust him from its enjoyment if the claim be not well founded. The conditions necessary for the issue of the writ of quo warranto are as follows: the office must be public, and it must be created by statute or by the Constitution itself. The office must be substantive one, and not merely the function or employment of a servant at the will and during the pleasure of another. There has been a contravention of the Constitution or a statute or a statutory instrument in appointing such person to that office. The fundamental basis of the proceeding of quo warranto is that the public has an interest to see that an unlawful claimant does not usurp a public office. It is, however, a discretionary remedy which the court may grant or refuse according to the facts and circumstances of each case. A writ of quo warranto may thus be refused where it is vexatious, or where it would be futile in its result, or nowhere the petitioner is guilty of laches, or where there is an alternative remedy for ousting the usurper. Where the application challenges the validity of an appointment to a public office, it is maintainable at the instance of any person, where any fundamental or legal rights of such person has been infringed or not. Quo warranto is thus a very powerful instrument for safeguarding against the usurpation of public offices. The article is based on Parliament's power to modify or restrict fundamental rights. The limitation upon the enforcement of the fundamental rights are as follows. Parliament shall have the power to modify the application of the fundamental rights to the member of the armed forces, police forces or intelligence organizations so as to ensure proper discharge of their duties and maintenance of discipline amongst them. In exercise of this power, Parliament has enacted the Army and Air Force Acts of 1950 and Navy Act 1957, which empower the central government to make rules restricting the fundamental rights of the defense personnel for the sake of discipline, which is absolutely essential to maintain the security of India. By the circular issued under such rules, Government of India has ordered that no concession can be offered in favor of any member of the defense forces for the purpose of offering prayer during the office hours. It is pity that a fundamental Muslim organization named All India Muslim Forum has raised objection against the circulars articulated by Muslim members in Parliament on various grounds. None of these grounds are, however, tenable in view of the express provision of Article 33 of the Constitution of India, which silences the argument that no such restriction was imposed in respect of Muslims during the British regime, and also that it would hurt the sentiments of the Muslims. Nor does the argument that the withdrawal of such concession would be contrary to the guarantee of secularism hold water, because firstly, Article 25(1) makes it expressly subject to the other provisions of this part in which Article 33 is included. Secondly, what Article 25 guarantees is equality of treatment as amongst different religions. If no such concession exists in favor of the members of any other religion, no question of discrimination against Muslim can possibly arise. Above all, the defense of the nation is a secular duty of each citizen of India, regardless of his religious beliefs or rights. Nothing can be followed by the independent republic which can possibly jeopardize the defense of the nation. Needless to say, this dangerous move should be nipped in the bud before it assumes an uncontrollable situation. In the name of Muslim sentiment, any softness shown to it would be anti-national. A similar instance was the claim of section of Muslims to postpone the elections fixed for February 1995 on the ground of Ramzan. This has, of course, been turned down by the Election Commission on the ground that no such religious plea can stop the electoral process. It is also doubtful if there is any religious scripture which requires Muslims to suspend their normal duties on the day of fasting, which is scrapped over 1 month. When marital law has been enforced in any area, Parliament may by law indemnify any person in the service of the Union or a state for any act done by him in connection with the maintenance or restoration of order in such area, or validate any sentence passed on act done while marital law was in force. The suspension of fundamental rights during proclamation of emergency. The fundamental rights guaranteed by the Constitution will remain suspended while the proclamation of emergency is made by the President under Article 352. The effect of such proclamation in this behalf is twofold. As soon as a proclamation of emergency is made, the states shall be freed from the limitations imposed by Article 19. This means that the legislature shall be competent to make any law and the executive shall be at liberty to take any action, even though it contravenes or restricts the right of freedom of speech and expression, assembly, association, movement, residence, profession and occupation. So far as these rights are concerned, the citizens shall thus have no protection against the executive or legislative authorities during the operation of the proclamation of emergency. The enlargement of the power of the state under Article 358 will continue only so long as as the proclamation itself remains in operation. Article 19 will revive as soon as the proclamation expires, but the citizen shall have no remedy for acts done against him during the period of proclamation in violation of the above rights. The other consequence depends upon the issue of a further order by the President. Where the proclamation of emergency is in operation, the President may be ordered declare that the right to move a court for the enforcement of any fundamental rights shall remain suspended for the period during which the proclamation remains in force. Article 359. In such a case, however, the right to move the courts would be revived after the proclamation ceases to be in force or earlier, if so specified in the President's order. In other words, if such an order is issued, the Supreme Court and the High Court shall be powerless to issue the prerogative writs or to make any other order for the enforcement of any fundamental rights, including those which are conferred by the article other than Article 19, with the exception of those conferred by Article 20 and 21. This order of the President, however, shall not be final. Such order shall, as soon as may be after it is made, be laid before each House of Parliament, and it will be within the competence of Parliament to disapprove it. The 44th Amendment Act 1978 has further provided that a law or executive order will be shielded under Article 358 and 359 only if the law in question contains a recital to the effect that it has been made in relation to the proclamation of emergency, and the executive order has been issued under such law. Secondly, Article 20 to 21 cannot be suspended by any order under Article 359. As the Constitution stands today, two other matters must be mentioned which limit the operation of fundamental rights as they were devised in the 1949 Constitution and are not confined to times of emergency but operate even in normal times. These are the exceptions to fundamental rights and the fundamental duties. Article 31A to 31D, introduced by successive amendments, constitute exceptions to the application of fundamental rights wholly or partially. Of these, Article 31D had subsequently been repealed by the 43rd Amendment Act 1977. The fundamental duties are 10 in numbers, incorporated in Article 51A Part 4A, which has been inserted by the 42nd Amendment Act 1976 under this article. It shall be the duty of every citizen of India to abide by the Constitution and respect the national flag and national anthem, to cherish and follow the noble ideals which inspired our national struggle for freedom, to protect the sovereignty, unity and integrity of India, to defend the country, to promote the spirit of common brotherhood amongst all the peoples of India, to preserve the rich heritage of our composite culture, to protect and improve the national environment, to develop the scientific temper and spirit of inquiry, to safeguard public property, to strive towards excellence in all spheres of individual and collective activity. I am going to talk about composite culture of India according to our Constitution. In this context, it would be better to remove a misnomer involved in the expression composite culture in Clause F of Article 51A. The Supreme Court has now pointed out that the foundation of this composite culture is the Sanskrit language and literature, which is the great binding force for the different peoples of this great country, and it should be preferred in the educational system for the preservation of that heritage, apart from the duty of the government under Article 351. To quote the Supreme Court, Though the people of this country differed in number of ways, they all were proud to regard themselves as participants in a common heritage, and that heritage emphatically is the heritage of Sanskrit. The reason is that the original population of India was Hindu. Thereafter, this country was subjected to Muslim and British rule. Because of its wonderful tolerance, the Hindu culture imbibed these alien cultures and thus grew up a composite culture in India. Hindu religion developed resilience to accommodate and imbibe with tolerance and cultural richness with religious assimilation and became a land of religious tolerance. Each religion made its contribution to enrich the composite Indian culture as a happy blend or synthesis. Our religious tolerance thus received reflections in our constitutional creed. Of course, there is no provision in the Constitution for direct enforcement of any of these duties, nor for any sanction to prevent their violation, but it may be expected that in determining the constitutionality of any law, if a court finds that it seeks to give effect to any of these duties, it may consider such law to be reasonable in relation to Article 14 to or 19 and thus save such law from unconstitutionality. It would also serve as a warning to reckless citizens against anti-social activities such as burning the Constitution, destroying public property and the like. The Supreme Court has held that since the duties are obligatory for a citizen, it would follow that the state should also strive to achieve the same goal. The court may therefore issue suitable directions in these matters in appropriate cases.